Uczony, filozof, wielbiciel i propagator dobrej roboty. Profesor Tadeusz Kotarbiński. Od wielu lat uosobienie polskiej myśli humanistycznej.
Ladies and gentlemen, it's my great pleasure to welcome you on behalf of the organizing committee to the conference entitled Workplace Whistleblower Protection in the Visegrad countries, France and Slovenia, entitled Current Regulations and Proposed Changes, managed by the University of Łódź online with cooperation of our partner organizations, namely Charles University of Prague, University of Maribor, Trnava University in Trnava, University of Tuv, Karoli Gaspar University of the Reformed Church in Hungary. I would like to thank the authorities of the University of Łódź and of the Faculty of Law and Administration of our university, as well as the partner organizations for all the forms of support given to the organizers. The conference is held within the Visegrad Grant, Workplace Whistleblower Protection in the Visegrad countries, France and Slovenia, which we shortly call WhistlePro Grant, which is co-financed by the governments of the Czech Republic, Hungary, Poland, and Slovakia through Visegrad grants from the International Visegrad Fund. And we are carrying out this grant during the years 2020 till the end of 2021. The aim of this grant is to develop a model proposals, a set of proposals for the effective protection of whistleblowers in the Visegrad countries, taking into consideration obligation to implement the EU Whistleblower Protection Directive by all the European Union member states by the end of this year. I'm very pleased and honored to welcome Mrs. Marianna Neupauerova, Deputy Executive Director of the International Visegrad Fund, and I would like to hand over the microphone to Mrs. Neupauerova, to Bratislava, so that we hear the welcome address from the International Visegrad Fund headquarters. Mrs. Neupauerova.
Good morning to everyone.
Good morning.
I cannot really get my video working, but maybe I hope that you can at least hear me.
Yes,
all right.
yes,
no,
yes.
All right.
Everything is perfect.
Thank you. Thank you, Professor. Good morning to everyone. Good morning to all the organizers, to all the participants, to the members of academia and all the law practitioners who will take part today, and all that are active in protecting the rights of whistleblowers. Bonjour à tous. I'm very happy to see that there's extended cooperation of V4 countries with other partners, namely in this case it was France and Slovenia, as Professor Skupin mentioned in the beginning. So it's my great pleasure to welcome you here at this scientific conference. At the IVF, I was once told that we have a very nice, very modern logo with those 4 dots. Well, those who don't know, it's the position of the V for capitals. And we are actually, the whole fund is here to connect those dots, to make and create connections in between people of our region and beyond this region. And I think the same role you have in your conference here, because you are connecting the dots. You are connecting the dots between the national legislations. You are looking for holes and gaps. You are connecting the dots with the European legislation. You are doing actually very important and interesting job here, which is not always automatically taken for granted in all grants and all activities that we see. So it really is an honor for me to be here and to welcome you here. You have chosen a very interesting objective, which is about providing safer environment and capacity building for whistleblowers. But it goes further. It's about fact checkers, investigative journalists, and other watchdogs. That's the objective, how we define here at the fund. And we very often have projects under this objective, but it usually is for the Eastern Partnership countries and Western Balkans. So therefore, it's very unique to have it here in our region, because we do have troubles in this very area, and we have a lot of work to do here. I'm very much looking forward to the results of the conference that you will reach. Please take it for granted that the fund is here to help you also with the dissemination of the results. Because as I read all the papers, and you are going to have in-depth discussions, the implementation period and the implementation of the European legislation will start as of the end of this year and maybe later on. And it will be wonderful to have it in all the legal communication, but the people have to know. All of us, I think, can one day find ourselves in shoes of a whistleblower. As we nowadays hear all around about hybrid wars, we go to sleep with the sustainable development in our heads. Whistleblowers, they wage out their own wars. It's a kind of hybrid war. It's a very new war, very unknown war. At least under the new conditions, it is. And sustainable development, again, I mean, it might sound a bit awkward, but it is a contribution to the sustainable development, because they are contributing to persistent adherence to the values and rules that we have. So it really is a challenge, and it's a mission. I would like to introduce a few numbers. I mentioned the objective that you have chosen, the organizers, but at the fund we are creating those connections. I mentioned in the beginning for 20 years already. And we were lucky enough to spend 100 million already over those 20 years for various grants and mobility projects, which were reached by 6,000 grantees, which is an immense number. So there really are those connections. And therefore, I'm really serious when I'm saying that we are ready to help you with the dissemination of the results and the dissemination of the information that you will gain and the conclusions that you will have. It's also very nice to see the professional organization of the event and of the results. I would like to really mention that it's a pleasure to see the University of Łódź with the Charles University, Trnava University, University of Tours, University of Maribor, and Karol Gaspar University working together. And I would like to wish you all very fruitful consultations, a very fruitful exchange of views. And I hope you will all enjoy it, and you will come back to the fund at some point. We are here for you, and we are ready to support you. Thank you very much.
Thank you very much, Mrs. Nepowerova, for your welcome address, for the warm words of encouragement addressed to us. Thank you. It's in fact much work to do in the area of whistleblower protection in the Central Europe. So we hope to contribute through our works, through our analysis, to the improvement of situation in this field. And as the program is really very rich, we are more than happy to have renowned speakers, wonderful audience. I would like now to open the conference, open the first session. of the conference. Before starting the substantial part, I would like to kindly ask you to mute your microphones as we are transmitting live this conference to the YouTube of the University of Lodz, and also to switch off your videos. Participants have the option of questions and answers. We as speakers, we have chat at our disposal, and please kindly during the sessions use these options so that we start the discussions smoothly with the list of questions of comments already written. And as it concerns the oral interventions, please kindly firstly indicate your wish to speak during the discussion, and due to the fact that we have 120 participants, please kindly limit your short comments, your short oral speeches to 1 minute. So let's start the first session. I hope that all speakers are with us. I would like to welcome Mrs. Maria Rosaria Molica, representing the European Commission.
Thank you very much.
Yes. Hello.
Hello.
I would also like to greet Professor Marcin Górski. Are you there, Professor?
Yes, I'm here, and thank you, Madam Chairperson.
Thank you. Professor Gwenola Barguin, University of Tours.
Hello.
Hello. Professor Daria Senczur-Peczek, University of Maribor.
Yes, hello.
Hello. And Dr. Zsuzsanna Baksa, who will be speaking on behalf also of Dr. Attila Gulyas. If you may confirm, Dr. Baksa, that
yes, I'm here. Good morning, everyone. Good morning. I'm sorry.
Okay, that's great. So we are talking, we are discussing, we are analyzing the EU Whistleblower Protection Directive during the works carrying out during the Whistleblower Grant, and now we are very privileged to be able to listen to the approach of the European Commission, to know the priorities of the European Commission concerning the implementation of this important directive in the member states. So I am honored and pleased to welcome Mrs. Maria Rosaria Molica, representing European Commission Directorate General for Justice and Consumers, Fundamental Rights Policy Officer, responsible for the whistleblowing issues. So the floor is yours, and we are very curious to know about the priorities, the essential elements in your opinion concerning the EU Whistleblower Protection Directive.
Thank you very much for giving me the floor, and good morning, everybody. It's a pleasure to be here and being given this opportunity to present the main elements of this directive. I'm going to try to share my screen, and you please tell me if you see my slide, my PowerPoint presentation.
Not yet, but
not yet.
There's a magic green button at the
I'm clicking on it.
Bottom of the screen.
That's what I'm doing.
It should be visible very soon. Oh yes.
Now it's visible.
Yes.
Okay.
Yes.
Wonderful.
Yes. It works.
Okay. Then we can start. Okay, I am a member of the team that drafted and negotiated this directive, which was adopted by the Union legislator in October 2019. Now, member states have until the 17th of December to transpose this directive into their national legal order. The Commission has set up an expert group which gathers representatives of member states, in particular the ministries which are responsible for the transposition of this directive, to try and facilitate a common understanding of the requirements of the directive, to facilitate exchange of best practices and share explanation of on questions that come up during the transposition period. We had the last meeting of this expert group yesterday. Apparently, member states are working hard to meet the deadline, and most of them are confident that their national law would be ready before the expiry of the deadline in December this year. So in my presentation today, I would like to walk you through the main features of this new protective regime that will ensure, once the directive is transposed, a consistent high level of protection for persons who report information that they acquired in a work-related context to reveal breaches of union law in a wide range of sectors. But let's start first with the personal scope. Who is protected under this directive? The personal scope is defined by reference to the definition of reporting person that you see on this slide. So the directive applies to persons in the private and public sector who report or disclose information on breaches, information that is acquired in a work-related context. And this definition includes the categories of persons that you see on the screen. This list is not exhaustive. Member states have to include all these categories in their national legislation, but what matters is the definition. The list is indicative, and as you see, it shows that whichever person that finds itself in the position of acquiring information in a work-related context can qualify as whistleblower under the directive. So as you see, it covers the classical situation, employee-employer under letter A, but also volunteers, persons whose employment relationship has ended or is yet to begin, self-employed persons, because what we want here is to tap into the potential of whichever person who in the workplace encounters information on breaches which would otherwise remain hidden and could never be brought to light. Oh gosh. And now I move to the material scope of the directive, which reports are covered. As you know, under European law, we cannot cover, we have certain legal constraints. We can only work in compliance with the principle of proportionality and subsidiarity. So we have defined the material scope by reference to those policy areas where breaches are very likely to cause a serious harm to the public interest, and where reports by whistleblowers is an essential element to ensure a strengthened enforcement of union law. And by applying these criteria, we defined the material scope by reference to these 13 policy areas that you see on this slide. Again, it's a very wide material scope. It goes from public procurement to environmental law, consumer protection, privacy, data protection, breaches that harm the EU financial interest, and so on and so forth. Now I go into the the gist of the matter, the architecture of the directive. Are you seeing? I have two screens, I have to say. So I have on one screen a different slide than the other.
Yes, it's great. It's great. Yes.
It's working. Okay.
Yes.
So the architecture of the directive is summarized on this slide, and then I will go one by one into these points. So the directive requires the setting up of internal and external channels for reporting. There is this important distinction to be made under the directive. Whistleblowers are encouraged to report internally within the workplace with which they have a relationship, and these are the internal reporting. Then, if that doesn't work appropriately, they can resort to external reporting, so revealing their information to competent authorities outside the place where they work, and only as a last resort can they resort to public disclosure, meaning revealing information to the public domain. Under the regime as it is in the directive, it is the whistleblower's choice to decide whether to report first internally and then externally, or to report directly externally to competent authorities. But member states are required to encourage internal reporting first. And the reason there is that it is, in most of the cases, more efficient to report internally, because the legal entity in the private or public sector is best placed to address and solve the issue quickly. But okay, this is it for the moment for the reporting channels. The directive also requires that procedures for reporting and follow-up are put in place, that any form of retaliation is prohibited and punished with penalties. The directive sets a few conditions for protection, we will see them, and also offers remedies in case of retaliation, including the reversal of the burden of proof and interim relief. This is a minimum standard directive. This means that member states may introduce more favorable provisions for the protection of whistleblowers. Moving on, sorry. Now, the internal and external reporting channels. When it comes to internal reporting channels, all private entities with 50 or more employees are required to set up internal reporting channels, and in the public sector, any public entity must have reporting channels, but member states may provide that public entities with less than 50 employees and municipalities with less than 10,000 inhabitants are exempted from this obligation. Moving now to external reporting, competent national authorities that member states have to designate must set up internal reporting channels which enable confidential reporting and which must be operated by specifically trained staff members. The procedures, the requirements, the most important requirements for these channels are the following. First, and most importantly, the confidentiality of the identity of the reporting person must be guaranteed, because it's the first means for the employer to put in place retaliation measure, is to get to be informed of who has provided and disclosed information. For that reason, it is essential and central that the confidentiality of his identity is respected. Second, as I said, a dedicated staff member or department must be designated within the legal entity for the function of receiving and giving follow-up to the report. An acknowledgement of receipt must be provided within 7 calendar days of the receipt of the report, so that the whistleblower is informed that his report has landed correctly where it should have been sent. A diligent follow-up must be given to the report, and by follow-up we mean any action which is meant to assess the accuracy of the report, to address the breach reported, and in some cases a follow-up measure would simply be to conclude that in fact there was no breach in the end. And also very important is that the whistleblower has access to a comprehensive set of information on the procedures and how reports can be made externally to competent authorities. The whistleblower must be able to make an informed decision, so information must be given upstream in the legal entities, in the private or public sector, but so that he knows how to prepare the report. And another important aspect of this regime is that feedback, so information on the actions envisaged or taken as follow-up and the grounds for this follow-up is provided to the whistleblower within a reasonable time frame, which must not exceed 3 months when it comes to internal reporting, or can be extended to 6 months in the case of external reporting. This is a very important requirement because in our consultation and study carried out before drafting the directive, it turned out that one of the reasons for which whistleblowers did not come forward with information was that they thought that it would be futile, that no action would be, no follow-up would be given to their report. With this obligation, we try to cater for that issue, and we oblige the receiver, the entity that receives, or the competent authority that receives the report, to inform the whistleblower about the actions envisaged or taken. And finally, when it comes to external reporting, the directive requires also that the whistleblower is informed about the final outcome of the investigation. As I mentioned earlier, any form of retaliation is prohibited and even punished with penalties. And by retaliation, one has to understand any direct or indirect act or omission which occurs in a work-related context, which is prompted by the internal or external reporting or by the public disclosure, and which causes or may cause an unjustified detriment to the whistleblower. So again, here it's the definition that matters, and the list of possible forms of retaliation that you see on the slide is just indicative, just to show that it can cover a very wide variety of forms of retaliation. There are a few conditions that must be met by the whistleblower to benefit from the protection of the directive. First, whistleblowers must have reasonable ground to believe that the information reported is true at the time of reporting, so malicious whistleblowing would not be protected. And second, it must have reasonable grounds to believe that the information reported falls within the scope of the directive. Honest mistakes are excused, so the whistleblower would keep the protection if with a honest mistake, he didn't meet one of these two or the two conditions. As I mentioned earlier, when it comes to public disclosures, a number of additional conditions must be respected. I will not go into those details for the sake of time, but keep in mind that that must remain a last resort solution. And finally, the directive provides for a set of measures of support covering, as I mentioned earlier, the obligation to provide comprehensive and independent information and advice on procedures, remedies, and protection against retaliation to the whistleblower, assistance by competent authorities to the whistleblower, and legal aid in criminal and in cross-border civil proceedings. Also, a number of measures of protection are offered to the whistleblower. The whistleblower will be protected from liability for breaching non-disclosure clauses, provided that revealing information protected by non-disclosure clauses was necessary to bring to light a given breach. The whistleblower will also be protected from liability for the acquisition of the information. Also in judicial proceedings, he will be protected from liability, for example, for defamation, for breach of copyright, and so on and so forth. There is this reversal of the burden of proof that must be applied. So it will be sufficient for the whistleblower to demonstrate that he first reported on a breach and then he suffered detriment, and it will then be for the employer to demonstrate that the detrimental measures were not motivated by the report or the public disclosure, but based on duly justified grounds. And finally, remedial measures that are available under national law must be offered also to the whistleblowers, including interim relief. Voilà, I see that I'm a little bit out of my 15 minutes, so I close here my presentation and I thank you for your attention.
Mrs. Molika, thank you so much for your interesting and comprehensive presentation. It was really very, very interesting to know about the main aspects which are the most important for the implementation of the EU Whistleblower Protection Directive. Thank you again.
My pleasure.
And now we are moving from Brussels to Lodz, where Professor Marcin Górski is awaiting us. Professor Górski is a renowned researcher in the field of human rights, also an attorney and head of the legal department of the local government of the City of Lodz office. And the topic which will be presented concerns the interplay between Article 10 of the European Convention of Human Rights and the EU Whistleblower Protection Directive. I think it's extremely important to remember that freedom of expression lies at the very heart of every whistleblowing act, of every courage, and even though the national acts on whistleblowing were very often justified by the fight of corruption, that were justified by the need to protect financial interests of a given state, it is always important to remember about the freedom of expression. And moreover, the directive draws upon the case law of the European Court of Human Rights on the right to freedom of expression. So we are looking forward to your presentation now.
Let me add that I'm waiting here, anxious and intimidated, as this is a very prestigious event, and I'm extremely honored and thankful to the organizers for giving me a chance to participate in it. And let me share the screen with the short presentation. Okay, I hope you can see it now. Can you see the presentation?
Yes.
Okay, that's
yes.
Okay, so ladies and gentlemen, very briefly, the directive, as it was already explained by Ma'am Molika, provides for measures concerning whistleblowers reporting breaches of EU law, which and the provisions of the directive aim at protecting the whistleblowers internally within a given organization. That's Article Article 7, externally Article 10, and while making public disclosures, Article 15. And what I'm going to focus on is actually Article 15. Recital 31 of the directive reads that this directive draws upon the case law of the European Court of Human Rights on the right to freedom of expression and the principles developed on the basis of Article 10 in the case law of the European Court of Human Rights. And obviously it is not the reference to Article 10 ECHR in the recitals of the directive, but above all Article 2 and Article 6, paragraph 1 of the Treaty on the EU, read jointly with Article 52, paragraph 3 of the Charter of Fundamental Rights, which altogether result in that the standard of safeguarding the whistleblower's freedom of expression provided for in the directive must be construed as at least equivalent to that stemming from Article 10 of the Convention. The interpretation of Article 10 of the Convention, the context of protection of whistleblowers, reaches back to the Moldovan case Guia of 2008. And since the delivery of the judgment in 2008, the Strasbourg standard has been consolidated and somewhat, I would say, universalized or generalized, so extended also to other fields than whistleblowing by public officials, because that was actually the main issue in the Guia judgment, in the Guia case. In Guia, the applicant alleged the breach, successfully actually alleged the breach of Article 10 as a result of his dismissal from the office of the Prosecutor General. And he was dismissed for divulging 2 documents which he viewed as disclosing rather grave interference by a high-ranking politician in pending criminal proceedings. None of these documents were classified as confidential. And after sending them to the newspaper, an article was published criticizing the public pressure in the public prosecution interference. The applicant was dismissed from his office. The reasons for his dismissal were that, first of all, the documents were confidential and that he failed to consult the disclosure of these documents with the heads of some departments of the public, of the Prosecutor General's office. And you probably all know that the court found in this case the violation of Article 10. The court said that although Article 10 applies also to the workplace and that civil servants such as the applicant enjoy the right to freedom of expression, the employees have a duty of loyalty, reserve and discretion to their employer. This is particularly so, says the court, in the case of civil servants, since the very nature of civil service requires that a civil servant is bound by a duty of loyalty and discretion. Nevertheless, the court expressed the view that a civil servant in the course of his work may become aware of in-house information, including secret information, whose divulging or publication corresponds to a strong public interest, and the signaling by a civil servant or an employee in the public sector of illegal conduct or wrongdoing in the workplace should in certain circumstances enjoy protection. This may be called for where the employee or civil servant concerned is the only person or a part of a small category of persons aware of what is happening at work and is thus best placed to act in the public interest by alerting the employer or the public at large. The court added that in the light of the duty of discretion, disclosure should be made in the first place to the person's superior or other competent authority or body. It is only where it is clearly impracticable that the information could, as a last resort, be disclosed to the public. So, like in many other cases, we have here the mechanism of balancing the competing interests, right? Protecting the confidence in public authority, reputation of the employer on one hand, and on the other hand, the general public interest in having the information on wrongdoing divulged, disclosed. And the court developed in the GUIA judgment the sixth element test, which lies at the foundation of the directive mechanism of what we have in Article 7, Article 10, and above all in Article 15. The elements of this test are here in the screen. So first, it must be established whether the applicant had any alternative channels to effective in order to prevent or combat breaches of law which he intends to or she intends to disclose. Secondly, while reviewing the proportionality of interference regarding the freedom of expression of a civil servant in such a case, regard must be had to a number of other factors, including in the first place to the public interest involved in the disclosed information, because the interest of the public may have may be sometimes so strong as to override even a legally imposed duty of confidence. Thirdly, the authenticity of the disclosed information is of relevance, but not the authenticity as such, but whether a person deciding to disclose information carefully verified to the extent permitted by the circumstances that that information is accurate and reliable. So precisely speaking, it does not have to be accurate, but he must put relevant effort in order to verify this prerequisite. Fourthly, one must weigh the damage, if any, suffered by the public authority as a result of the disclosure. The subject matter of the disclosure and the nature of the administrative authority concerned may be relevant, says the court. Fifthly, the motive behind the actions of the reporting employee is another determinant factor in deciding whether a particular disclosure should be protected or not. The sixth element is that the review of the challenge interference must concern also, as usual in the case law of the Court of Justice of the European Court of Human Rights under Article 10, the severity, proportionality of the sanction applied in respect of a whistleblower. A structurally similar case was Butzer and Toma versus Romania. Excuse me for my poor Romanian. In this case, we had a Secret Service officer convicted for public disclosing during a press conference state secrets concerning illegal surveillance regarding business persons, journalists, politicians, and so on. And in order to contextualize this GUIA standard, we need to be aware that on one hand, sometimes the court disqualifies an action as a whistleblower action, and that's the case Aurelia Nopea versus Romania. We had the applicant publicly accusing the academic community of corruption and scientific dishonesties. Basically, the court found that that was not whistleblowing. On the other hand, we have a number of cases where the court actually refused to afford the whistleblower protection, so refused to afford the protection under Article 10, even though the action was classified as a whistleblower action. Here you have cases like Soares versus Portugal concerning an applicant being an officer of Guardia Nacional Republicana who was sentenced for a minor fine of €720 and a disciplinary sanction of suspension duties for 6 days. He was the sanction was actually conditionally suspended also as a probative measure. And he was sentenced for these sanctions for insulting his principal through accusing him in a letter addressed to the internal auditing service of the Guardia of a certain embezzlement. The court emphasized that the applicant was aware from the very beginning that his allegations were based on rumors, right? So the question of authenticity occurs here. Cases like Gavlik versus Liechtenstein, a very interesting case, I would say, because it concerned a doctor of medicine who was dismissed without office for notifying the public prosecution. Apparently, that was quite baseless. of a suspicion of crime of illegal euthanasia without, however, having previously verified those allegations in any way, except for simply noting that 4 patients died after being given doses of morphine, right? Or Mezlis Islamskie Zajednice Brczko, the case which concerned, an organization who was well sanctioned for defamation occurred or committed in the course of proceedings aimed at appointing the head of the local radio. You need to be aware of this particular political context, right, which appeared there. And thirdly, we have cases which generalized the GUIA standard, starting with Heinisch versus Germany of 2011, the case concerning a geriatric nurse employed in a state-owned company providing medical services. The nurse was fired without notice after she informed the prosecution of the suspicion of crime allegedly committed by her employer, and accusing the company of serious shortcomings in the daily care provided there, caused by a shortage of staff. The court noted that, and that's the main issue here, that information disclosed by the applicant was undeniably of public interest. So the status of the employer seemed to be less relevant in the circumstances of a case. And then we have a series of cases like Marchenko versus Ukraine. The person who was the addressee of the interference was a teacher and a trade union activist. Matus versus Hungary, journalist in a public television company. Rubins versus Latvia, academic teacher. So it does not, the standard does not limit itself to actually the strictissimo sensu public officers, right? It's more general. And then Article 15 of the directive allows for using public disclosure where the whistleblower makes an internal report, but no appropriate action was taken in response to the report within the limit of 3 months in case of internal reporting, or 6 months in case of external reporting, or where the whistleblower has reasonable grounds to believe that the breach may constitute an imminent or manifest danger to the public interest. I will just make a short note here that there are certain doubts concerning the way in which the directive was translated into Polish. Actually, the word reasonable grounds to believe, right? That was translated in the official translation of the directive to the Polish language as uzasadnione podstawy, by sądzić. So reasonable grounds is less than uzasadnione. Uzasadnione is legitimate. This is something more, and it actually reduces the standard of protection. This translation would reduce the standard of protection afforded by the directive, should we be unaware, obviously, of the rules on interpretation of the directive, right? So that we have to take into account different language versions in order to catch the real norm contained in the provision. And then by sądzić. Sądzić means to, in Polish, to assess. Right, that is something more than to believe. To believe, croire, is just to have grounds in order to assume something, and sądzić is something more. So there are these irregularities in translation which I would like to make just a short note about. And if we try to compare the standard of Article 15 with the GUIA standard, then I guess we should make 3 remarks here. Firstly, and most obviously, the directive, under the directive, the motivation of public disclosure is irrelevant, right? And that's a very clear difference between GUIA and Article 15. Recital 32 of the directive reads explicitly that the motives of the reporting persons in reporting should be relevant in deciding whether they should receive protection. Secondly, uncertainties arise in respect of in my view, in respect of formulation of circumstances justifying public disclosure defined in Article 15 of the directive, if viewed from the perspective of the first element of the GUIA standard. Let me rephrase the first element. The first element of the test, of the GUIA test, assumes that the whistleblower is protected by freedom of expression where he or she entered the public disclosure in the absence of any other effective means of counteracting irregularities that he or she intended to disclose. At the same time, the directive reads in Article 15 that the whistleblower can either report internally or immediately externally, and then wait, I would say somewhat in vain, until the applicable time frames for reaction of addressees of his or her reporting expire ineffectively, or she can divulge information publicly only where reasonable reasons exist to believe that there is a risk of imminent hazard to public interest or that there is a risk of retaliatory measures of or ineffectiveness of milder whistleblower actions. In other words, immediate public disclosure is exclusively permissible, so protected by Article 15 in cases of imminent or manifest danger to the public interest. And let's call it prerequisite of imminence, right, which is enshrined in that provision, or more discreet of retaliation, sorry, I had to switch off the mobile. So when more discreet whistleblowing action implies that the risk of retaliation effectiveness, which we can jointly refer to, assuming that it includes also the retaliatory revenge, as such retaliation results in reducing the effectiveness of whistleblowing, because the latter is not intended to have the output of the whistleblower is losing a job. At the same time, the first and the fourth element of the GUIA test, read jointly, appear to allow for the conclusion that the way in which the interest which a whistleblower intends to protect is endangered, which is whether the interest is threatened directly and manifestly or not, does not seem to have significance for the protection afforded by the convention. What is relevant, though, is whether a whistleblower entertained alternative channels of communication of his or her allegations, so whether he or she made use of more discreet whistleblowing actions, and whether the balancing of interest potentially impaired by reporting or divulging and the interest protected by whistleblowing proved that the former were outweighed. As the significance of the endangered public interest can be so heavy that it results in absolving a whistleblower for employing internal ways of reporting. Hence, where the public interest in disclosure outweighs possible detriment to the entity affected by such a disclosure, neither the way of endangering the public interest nor the occurrence of the prerequisite of imminence, in the meaning that I presented above, should impact the scope of protection afforded by Article 10. So here there may be some gap between the GUIA standards and Article 15. And thirdly, certain minor doubt arises when one compares Article 15 and the GUIA test in reference to the link between the exculpating prerequisite of public disclosure and the protection of the public interest. Obviously, the said link is, as such, is appropriate since the directive applies solely to reporting on disclosing irregularities allegedly breaching the union law, and therefore its function, clearly differently than under Article 10 of the Convention, is to protect the financial interest of the union and not the freedom of expression as such, right? So the rationale behind it is basically different. That is also the consequence of the treaty basis of the directive, which was Article 325, so the protection of financial interest of the community, of the union. Yet on the other hand, the wording of Article 15, paragraph 1b1 is likely to cause interpretative uncertainties in cases where the reported or disclosed irregularity occurs in a private sector entity and not in a public one. In such a case, a perpetrator of irregularity ultimately impairs the interest of a private entity in the framework of which he or she commits this irregularity. The financial interests of the union would be protected by the very whistleblower's action. So that's what he or she aims at. And the private entity would be ultimately held responsible with all the legal and financial consequences thereof. While construing the proviso of Article 15, paragraph 1b1 of the directive, one should beware basically of the general function of the directive and of avoiding interpretational shortcomings leading to the flawed conclusion that no public interest was endangered if a whistleblower reported or divulging irregularities in a private entity. But that's not the problem of the directive, that's the problem of possible interpretation thereof. I want to stress this point. Thank you very much for your attention.
Professor, thank you so much for such a great enriching presentation, and also for the linguistic suggestions, possibly for the Polish transposition of the directive. Thank you so much. And now Professor Gwenola Barga from the University of Tours, a renowned specialist in labor law. I hope that you are ready for the presentation. The French law was chosen as the inspiration for our research, but it seems that there are also some shortcomings in the present legislation which could be mended during the transposition. Professor Barga, we are looking forward to your presentation. It is visible.
It's visible, it's okay for you?
Yes, if you could move into the presentation of slides.
Yes. Is that okay?
Yes.
Okay,
great.
Thank you very much, Dagmara.
Thank you.
Hello, everybody. Thank you very much for inviting me to this conference. And of course, it's a great pleasure to be here in my office, but it's a pleasure to be here. So the French legal framework for whistleblower protection may appear to be particularly well developed. Indeed, since the so-called Loi Sapin 2, we have general criteria to qualify a whistleblower. We have procedural and substantive guarantees against possible retaliatory measures. But the system is not complete and its shortcomings are obvious, and the transposition of the EU directive could be seen as an opportunity to correct the limitations of the current system. So Article 6 of the Loi Sapin 2 does not exactly define whistleblowing or whistleblowers, but it does provide a legal qualification which implies protection of the whistleblower. But I think it's very important that it should be remembered that the decision to institute a general framework for the protection of whistleblowers in France was not made suddenly. Originally, the whistleblowers was conceived as a person who reveals a risk to health or environment. Then the whistleblower has emancipated from this unique dimension to become part of the public policy issue of transparency. And now a whistleblower is the person who reveals violations of the law, becoming part of a kind of compliance scheme. And indeed, the protection of whistleblower has been integrated into the Loi Sapin 2 with a view to fighting corruption and financial offenses. But we have as well a specific legal framework at work We have a kind of collective alerts, which is recognized for employee representatives in case of infringement of personal rights, in case of serious and imminent danger, in economic matters and in social matters. So the difficulty is to have or to grasp a unitary approach of the alert in France, because we have the general framework and we have some specific legal alerts. Then it is as well difficult to assess the impact of this legislation, given its early date, 2016, and the shortcomings of the current French legal framework are, to my opinion, based on three main issues. First, the problem is the scope of this protection. The scope of this protection must be defined more broadly. Then the overly restrictive procedural framework must be corrected, and then the protections provided must also be strengthened. So first, we have the problem of the scope of whistleblower protection in France, and there is a need to revise this scope of whistleblower protection. The first limit is that the limited protection due to the multiplicity of legal criteria for whistleblower qualification. The emphasis is in France on the seriousness of the breach. What is important is the serious breach or serious harm, or as you can see, serious threat or prejudice to the general interest. So we have as well the legal requirement for the crime or the offense, but we have this requirement for other breach to be serious or very important. So this requirement could be a deterrent as it places the burden of assessing the seriousness of the breach on the person reporting it. So in the hypothesis of violation of a safety rule, for example, that would not be considered sufficiently important, and this would imply that the person could not benefit from this qualification. And this is a very important thing because it's different with the directive, because the directive offers a distinct approach by targeting the violations concerned not with regard to their degree of seriousness, but with regard to the areas in which they occur. So, of course, by offering a restrictive list of the areas concerned, the directive offers a more restrictive approach than the alert conceived in French law. But for the areas concerned, the qualification will be broader than that provided for under French law, since this qualification is not conditional on any seriousness. So it may be simpler in this case to identify the area of the protected alert based on a more objective approach. Then we have the problem of a restrictive context. In France, there is the requirement of a personal knowledge of the violation. It is not necessary for the person to act in a professional context, but the whistleblower must have personal knowledge of the facts. And as you can see, the whistleblower must act in a disinterested manner and in good faith. So we have two conditions, disinterested action and good faith. And so this is a difference with the directive because as we have seen, the directive is primarily concerned with the whistleblower reasonable grounds for believing that the information reported was true. So the motivation of the whistleblower is actually irrelevant. So then we have the question of the personal scope of the protection, because in France, in the context of the transposition of the directive, the opinions rendered are quite unanimous in deploring the restriction of the personal scope of application of whistleblowers to natural persons. Several arguments are used to defend this extension of the protection linked to the status of whistleblower. First, the defender of rights affirmed that this will make it possible to give a collective character to the alert and to break the solitude in which the whistleblower can be. So this is a first argument, and then we have the Commission nationale consultative des droits de l'homme, which considered that status of facilitator should be extended to any legal entity. So the scope of whistleblower protection in France differs from that of the European directive, and the results of the application of these very restrictive conditions underline the need to reconsider these criteria. Similarly, I think that the procedure put in place to guarantee the protection of whistleblowers appears too complex. In France, we have a three-step procedure. The choice has been made to favor an internal reporting procedure within the whistleblower's professional framework. And the first stage is characterized by the legislator's desire to give priority to the internal handling of the alert within a hierarchical framework and not with regard to any particular capacity of expertise held by the recipient of the alert. So the whole constraint of such a graduated system rests on this assessment of the treatment of the alert within a reasonable time, because it seems very uncertain for the whistleblower to determine whether the time elapsed can be considered to constitute a reasonable time, especially since he or she may be in a particularly vulnerable situation due to the disclosure. So the French legal framework differs from the European concept of reporting channels, because the directive in its Article 7 provides for this purpose that member states encourage the use of internal reporting channels, while indicated that it should happen on condition that the author of the report believes that there is no risk of reprisals. So it is left to the whistleblower to assess which channel is the most appropriate one for the alert in view of the professional risk involved. So there is a choice, and in France there is no choice. So Article 10 also states that the alert may be made internally or directly through external reporting channels. So then there is the question of the public disclosure, because we have just some exceptions allowing a public alert to assume either that it intervenes as a last resort or that the author of the alert is confronted with a serious and imminent danger or in the presence of a risk of irreversible damage. So this is another difference with the exceptions provided for in the directive. And in view of the difficulties posed by the gradation reports in the French legal framework, it seems necessary to develop institutional support for whistleblower. In this context, in France, currently, it seems even easier for the person who has made a report without respecting the procedure and who is subject to disciplinary measures to argue that the freedom of expression has been infringed, and not to argue to be a whistleblower. So the issue at stake beyond these procedural limits is the handling of the alert by the defender of rights, because in France, the defender of rights has a constitutional status and he can intervene to give information about whistleblowing, but the problem is that of the means available to the defender of rights. So currently, a proposal has been made to create a general inspectorate for the protection of whistleblower. So then the question is how to give a better protection to whistleblowers in France. We have limited measures of protection because the general purpose of the legal framework in France is to guarantee protection against possible reprisals. We have the confidentiality of the report and the lack of criminal responsibility, which are at the core of this protection. But in France, the protection of whistleblowers was conceived in the context of the fight against discrimination. And under the influence of EU law, the question is to prevent discriminatory measures. So no person may be subject to a discriminatory measure for having reported or testified in good faith to facts constituting a misdemeanor or a crime, or for having reported an alert. So then what is the most deficient part of whistleblower protections in France is the lack of material support. Support for whistleblowers is essentially conceived in terms of one institution, the Defender of Rights. Beyond this institution, there are few elements designed by the legislator to develop support measures for whistleblowers. So, in the French conception, currently, the whistleblower should be disinterested, and a certain ethics would imply that he or she should not receive any financial compensation for this alert. But in the context of the transposition of the EU directive, the Defender of Rights noted that the Sapin II law did not provide a sufficient framework for the conditions of handling and follow-up of alerts. She proposes to consider compensations for whistleblowers through financial aid to compensate for the loss of income and the creation of a specific fund. So at the end of these 4 years, the effectiveness of the protection designed for whistleblowers appears more than limited. So in view of this various problem, the transposition of the directive offers an opportunity to remediate these shortcomings. So thank you very much.
Thank you so much. Grand merci, Professor Barga, for this interesting presentation of the current situation in France, for your proposals, which certainly also will be included in the book we are preparing at the end of the grant. And so from France, now we are moving to Maribor, to Slovenia, the country which is also very advanced in protecting whistleblowers. However, as Professor Daria Senchur-Peček will explain, there are also shortcomings and things to be improved. Professor Daria Senchur-Peček is a internationally renowned labor law researcher, professor at the University of Maribor, and also vice dean for international cooperation and research of the University of Maribor. So, Professor, the floor is yours.
Yeah, thank you, Dagmara. First of all, I would like to express my gratitude to be a part of this project, and of course, I'm happy to be with you today. Although it would be better to be in Łódź, but what can we do? So maybe next time we will meet in person, I hope. So as the Slovenian regulation of the whistleblowing is concerned, at the moment, currently, we have limited special protection of whistleblowers or of person reporting certain acts, certain wrongdoings, for example, acts of corruption, and we have limited protection of of workers working in certain sectors reporting breaches of the legislation, and we have, in my opinion, adequate general labor law protection of employees, of course, including also employees, whistleblowers. So that's the starting point. Now when we have to, of course, transpose the directive, as we have heard today, member states are working on it, and Slovenia is among them. As I'm informed, the Ministry of Justice has been preparing the draft law, but since now this has not been presented to the public yet, so unfortunately I cannot present any legal solutions from this act, but I will try to address some dilemmas concerning the implementation of the directive and offer some perspectives directed to the improvement of the existing mainly labor law protection of whistleblowers. I will focus on labor law protection. As current legislation is concerned, as I mentioned, there is no special legal act in Slovenia comprehensively protecting whistleblowers, but we do have this Integrity and Prevention of Corruption Act, which, in my opinion, regulates this. I mean, this is a certain level of protection of people, of person reporting the corruption. And then we have this limited protection in banking and financial sector, and this general protection of employees through the Employment Relationship Act. Of course, there are certain specific provisions in other acts, for example, Inspection Act and so on, but this protection is limited, is spread in many separate laws. So in my opinion, and this is also the opinion of ministry, we need a new special act in Slovenia. This new act, of course, will have to reference to other existing laws, and of course amendments to the applicable legislation will be needed to ensure, of course, the compliance with the directive, and also to enhance the protection if we want to have the comprehensive protection of whistleblowers in the future. Now, what as the personal and material scope of the protection is concerned, according to the Slovenian legislation, in this special protection, as I mentioned, in this Integrity and Prevention of Corruption Act, and also in banking sector, this protection is given only to employees and civil servants reporting the wrongdoings. And also, of course, employment legislation protects only employees and civil servants. Okay, there are certain provisions, for example, in Prevention of Money Laundering Act, which gives the protection not only to employees, but also to person having comparable status to an employee. And yes, Slovenian Employment Relationship Act gives certain limited protection to certain circle of persons who are not employees. For example, limited protection to economically dependent person working on civil contracts but being economically dependent, to students working on occasional work of students, to voluntary trainees. But this is just limited protection. So in the new law, of course, if you want to follow the directive, and in general, of course, this circle of protected persons should be broader, should cover not just whistleblowers, but also persons associated with them, should cover not just employees and civil servants, although, of course, labor law protection is the most important for workers, but we should protect not employees, people having contracts of employment, but workers in a broader sense, according to the Court of Justice EU case law, and of course to other persons who are connected to employer in other sense, for example, members of company bodies and so on. As the material scope of protection is concerned, as I mentioned, of course, according to the Slovenian regulation, only employees and civil servants reporting corruption and reporting wrongdoings of the financial and banking legislation are protected, especially protected. According to the aim to enhance the protection. Of course, this new law should have this horizontal approach, not sectoral approach, not to protect just person reporting breaches of sectors of certain in certain sectors, but a horizontal approach. So we should give the protection to person reporting the breaches of EU law, of national law, and regardless of the field to which the violation relates. Maybe I forgot to mention regarding the personal scope of protection. As regards the conditions for the protection, according to the Slovenian Integrity and Prevention of Protection Acts, the conditions are that the person has reasonable grounds to believe that the information was true and good faith. So, but according to the data, among more thousands of reports of corruption, only few of them were malicious. So I don't think that there is a need to have this additional condition of good faith in the new law. But as I said, this is just my opinion. Now, internal procedures. According to the financial and banking legislation, there is already an obligation of certain employers in this sector to establish internal channels for reporting violations, and certain codes of conduct of huge companies in Slovenia already also defines certain internal channels. So I think that Slovenian legislators should consider the experience of those employers already who have already established internal channels. But additionally, in my opinion, the new law should establish not just those channels, but also define the obligations of employer, not just not to disclose the identity of the reporting person, but also the obligation regarding the protection of whistleblowers and the sanctions for non-compliance with this, for example, minor offenses and so on. Additionally, in my opinion, the detailed regulation of those internal procedures should be left to employers, and they would have to include employees' representative in it. In Slovenia, works councils are active. You also have trade unions in companies, so both would be appropriate, both ways or both forms of employees' representatives could be included. And what is the most important in connection to internal whistleblowing is that, in my opinion, employees will follow this route. They will use this internal channel if they have the confidence in it. And they will have the confidence if they have the confidence in person who is responsible for receiving reports. And we have such experience in Slovenia because, according to Slovenian legislation, employers have to define the internal channel for reporting workplace mobbing. And they have to designate a person who is responsible for receiving those reports. And we can see that if employees do not trust this person, and this is so, especially if this person is employed by the employer, then maybe they will not use this channel. So maybe best option would be external professionals hired by employer, or I don't know, platform providers or something like this, or even employees representatives. So this is just those are just ideas. And in Slovenia also anonymous report is possible. It's used in practice according to the legislation in force. So I think that we should have this option also in the new law, because this is the most, how should I say, the most confident. I mean, this is the most safe option for employees, and they will more likely use this channel in this case. So if we turn to the external channels, Integrity and Prevention of Corruption Act and also Financial and Banking Acts do provide the obligation to, or define the certain broad rules regarding the external procedures for employees to reveal certain irregularities and of course corruption. And there are certain very good solutions in the legislation regarding the protection of whistleblowers' identity, regarding the possibility of anonymous reporting, then the sanctions for employers that for the bodies that reveal the identity of whistleblower and so on. So I again think that we should, in the new law, use those solutions. And in my opinion, and as I'm informed, probably that would be the opinion of the ministry, but I'm not sure, that the Commission for the Prevention of Corruption could be seen as a body. This was the idea maybe a few months ago, I don't know what is now, that the Commission for the Prevention of Corruption could be seen as the body for receiving applications and for forwarding them to the competent authorities, as this commission already has some experience in this area. But of course, even if the new body will be established, this new body could use the experience of this commission. As the public whistleblowing is concerned, according to Slovenian legislation, at the moment, the legislation does not answer this question whether a whistleblower should use the internal channels first, except the Integrity and Prevention of Corruption Act, which gives the option to the person to choose the internal channel first or to go to public directly. And there is no specific legal protection of whistleblowers from civil liability and liability for violating the obligation of loyalty to the employer. But of course, there is a constitutionally guaranteed freedom of expression, which, as we all know, is not unlimited. So we may have this collision between freedom of expression of employee and constitutionally protected rights of another person or employer. And the court will have to weigh those two fundamental rights. And in certain Slovenian cases, labor courts has already regarded this matter of proportionality or disproportionality of the dismissal of the employee who was dismissed as a result of public disclosure of certain acts at employer. And the courts were following the criteria from the decisions of the European Court of Human Rights, as we already heard before. Now, of course, according to the directive, as we already heard, there is a question of the interpretation of the concept of imminent manifest danger, of the risk of retaliation, and so on. And even though the Court of Justice will follow those criteria from the European Court of Human Rights, still certain uncertainty will remain. I don't know in how far the legislation can reduce this uncertainty. Maybe in a way that certain temporary safeguards would be provided for whistleblowers until the occasion, until all the facts of the case are clarified. I don't know, but I think that this certain uncertainty here, it will be a great obstacle to the public, to the protection of public whistleblowers. Now, of course, the protection of the whistleblowers is the main aim of the new law. Should be the main aim of the new law, according to the Slovenian legislation in force. As I mentioned, this Integrity and Prevention of Corruption Act includes some protective measures. For example, right of the whistleblower to claim compensation, the assistance of the Commission for Prevention of Corruption in establishing the causal link between the retaliatory measure and the report of the corruption, which is, in my opinion, very important. Then the authority of the Commission to demand that employers should stop the retaliatory measures. already the reverse burden of proof, and the right of public servants only, not other employees, the right to be transferred to another work post if work at the previous work post is not longer possible after the report of the corruption. So I think that new law should contain, of course, this general ban on any retaliatory measures, but at the same time use certain protective measures from this sectoral legislation, of course, extended to all whistleblowers, not just to whistleblowers revealing the corruption. Additionally, as I mentioned, Slovenian labor legislation protects employees in general, on general level, and employees are protected in case of harassment, mobbing, discrimination, and this reverse burden of proof is already enacted. Also, the compensation in such cases has to be effective, proportional, has to discourage the employer for repeating the violation. So this could be the model also for, in general, for the compensation in case of the damage caused to whistleblower. And the protection against unlawful termination of employment contract, according to the Slovenian legislation, it's protecting employees. Employers need a justified reason. There are certain unfounded reasons for the termination. Unfortunately, whistleblowing is yet not one of them, but I think it should be. And there is a judicial protection awarded to employees in case of termination of employment contract. And if this dismissal was illegal, of course, employee can be reintegrated to the employer, again reintegrated to the employer, to the old workplace. So in my opinion, this general labor legislation should be, or this general protection should be supplemented with more concrete protection for whistleblowers. For example, as a presumption that a measure against whistleblower is a retaliatory measure. So using this reverse burden of proof, maybe the possibility of the competent authority to withhold, to temporarily withhold retaliatory measures. We have such provisions in the law already. For example, labor inspection can withhold this dismissal of the employment contract in certain cases. So maybe the inspection or any other body could have such competence in regard the whistleblower being dismissed, for example. Then, of course, the reporting of infringement or whistleblowing should be classified as an unfounded reason for termination. Maybe whistleblowers could be specifically protected as a specifically protected category, similarly as, for example, employees' representatives already are, and their position cannot be, the so-called non-regression clause, or there are some other possible solutions, of course. And of course, the validity of labor law protection should be extended to not just to employees, but to workers in a broader sense, as I already mentioned. So to conclude, this new law, of course, could only have the aim to comply with the minimum requirements of the directive, or could aim to provide the comprehensive protection of whistleblowers. And if the latter is the case, of course, then the new law would have to cover the wide range of protected person in relation to disclosure of all irregularities. This protection, of course, should cover fields of labor, civil, and criminal law. And if I focus on labor law, I think we should use some solutions that we already have in Slovenian sectoral legislation, but certain amendments, of course, will be needed. And maybe just for the last sentence, that's just the first step, yes, to have the good or excellent legislation. But next steps are much harder, yeah, to implement this in practice and to supervise how this is implemented. And this is the great role of the inspection and the courts here, as I can see. Thank you for your attention.
Thank you, Professor, for this interesting set of proposals for improvement, which of course are not only source of inspiration, as I suppose, for the Slovenian lawmaker, but also for other legislations of our countries. Thank you. And now I'm looking forward to the presentation of Dr. Zsuzsanna Baksa, also on behalf of Dr. Attila Gulyás. We are speaking about the best way to organize structures of external channels, and your survey certainly concerns the external channels. So we are very curious about the results of the survey. I only would like to add that Dr. Zsuzsanna Baksa is a deputy head of the Department for the Protection of Whistleblowers and Client Service of Office of the Commissioner of Fundamental Rights in Hungary. Please, the floor is yours.
Thank you, Dagmara. Good morning, everyone. So first of all, I would like to thank you again for the opportunity to be here, to be part of this unique event, especially as a speaker again on behalf of the Commissioner for Fundamental Rights of Hungary. And special thanks to the organizers for making all the efforts and help they did to make this event alive. So I'd like to share my screen, and I hope you will see it soon. Just a couple of minutes, probably. Yes, I can see it, so I'm sure you can also see it. So just to refresh what I said last year about the Office of the Commissioner for Fundamental Rights, one of the main directions of the whistleblower protection system in Hungary is that the Commissioner for Fundamental Rights ensures that an electronic system for making and recording public interest disclosures is operated. So our department, the Department for Protection of Public Interest and Client Service, operates this system. This is basically an external reporting channel with a central role in accordance with the directive, even though it is not implemented yet. So as you could already read in our abstract, if you had the time for it, since the Commissioner wishes to support the implementation of the directive, he has been started a comprehensive inquiry on the existing internal and external channels. So this is the situation before the implementation of the directive. Existing internal and external channels of state bodies, authorities, institutions on the base of Act on the Commissioner for Fundamental Rights. Nearly 100 questionnaires have been already sent out to the ministries, firstly, to government offices, secondly, and to thirdly, national competence authorities, and an additional 70, 60 is on their way. The feedback so far has been positive about the inquiry, and the bodies who have been contacted us, they're willing to respond. So this means that we don't really have the results yet. So I'm deeply sorry for it. But however, in the context of the legislation on whistleblower protection and its review, we are currently conducting a number of inquests, which we have brought together as a project. So the comprehensive inquiry will rely on the following 4 pillars. The comprehensive inquiry itself on the internal and external channels of state bodies. Secondly, we are dealing with digital whistleblowing platforms. For example, there is an association for pedestrians. This is an NGO for city passengers, and they are dealing with mainly road problems. This is what we call a digital whistleblowing platform, and we are inquiring their situation, their status in the whistleblowing system. And thirdly and fourthly, we are dealing with special procedures. There are authorities who have special regulations according to their own legislation, and their whistleblower report procedure are not under the scope of Act on Complaints and Public Interest Disclosures, which is our National Whistleblower Act at the moment. So let me show you the comprehensive inquiry itself. So in accordance with Section 1 of Act on Complaints and Public Interest Disclosures, public bodies and local governments shall assess complaints and public interest disclosures according to this Act. As I already mentioned last year, according to section of the same Act, public interest disclosures may also be submitted through this protected electronic system operated by the Office of the Commissioner. Through this electronic system, the Office of the Commissioner is currently in contact with nearly 280 state bodies. These are authorities, organizations, local governments, and in our experience, these reporting channels operated by state bodies in accordance with Act on Complaints and Public Interest Disclosures do not necessarily make difference between internal and external channels at the moment. So this is the status quo before the implementation of the directive. So as I said, nearly 100 questionnaires have been out. We have in the questionnaire mostly yes and no questions, and some of them need to be answered as well. There are 33 questions, which we can put mainly into 6 groups. There are questions on the existing external and internal channels, the procedure of the channel, available information and communication on these channels, personal data protection, protection against retaliation, and we obviously need some statistical data. So let me show you the first group. The first group is questions about the existing external and or internal channel. These questions are, does your organization have an external or internal reporting channel? Yes, no, 2 in 1, none, maybe they don't know. If it is an internal and or external reporting channel at the organization, is it used and operated independently or jointly with another organization? How the whistleblowers can report. This question also belongs to point 3 as well, which is the available information. So what is the purpose of this channel, of the internal reporting channel? We believe that according to a government decree, these internal channels are mainly for reporting corruption or non-ethical behavior, coordinating employer interests, or if there anything else. How can we use the internal channel by employees of a supervisory or anybody else? So these were the questions on the first group. The second group questions are the procedure of the channel. How and where is this procedure of internal and or external reporting channels regulated? Does the organization have automated procedures in place to ensure the confidentiality of information and other data obtained through the internal or external reporting channel? On what base do they decide which procedure should be followed if the internal and external channel is not separated? The third group contains questions on available information and communication. For example, is there any publicly available information on using these channels, how it is communicated, how the whistleblowers can report in writing, by post, by email, by a website, orally by phone, in person, or is there any other possibility for them? The fourth group is about the personal data protection. This is also very important to ask what kind of personal data do they record? Name, address, email, phone number, what else? How do they secure personal data of the whistleblower? Is there a responsible employer who is independent or not? Is there special requirements for the responsible person? Is there a special protocol for storing the reports? For example, the reports are stored in a special room, or is there anything else what they can say us? The fifth group is about the protection against retaliation, which is regulated recently in our Act on Complaints and Public Interest Disclosure. So we ask, how is the whistleblower protected against retaliation? And also, it is also regulated that how did they have any report in which the whistleblower provided in bad faith, decisive, untrue information, and what measurements were taken or procedures started in these cases? And finally, as I mentioned, we do need some statistical data. So we ask about how many whistleblowers report they are receiving on an annual basis, how many is considered to be well-founded, what are the main types of these reports, and in how many cases did it become necessary to contact another authority. And it is also important for us because we are the central body, or we have this central role in the protection of whistleblowers if the organization is registered in this electronic system operated by the Commissioner for Fundamental Rights or not. So this is the first pillar of our comprehensive inquiry. And the second, as I mentioned, the digital whistleblowing platforms. So according to act on complaints and public interest disclosures, anybody may submit a complaint or a public interest disclosure to the body entitled to proceed. There are already several communication interfaces in Hungary that have the transmission of whistleblower reports. And as I mentioned, this is this Association for Pedestrians, járókelő.hu, and also there's another one which is átlátszó.hu. And the practice of the state bodies for handling the reports transmitted by these so-called digital whistleblowing platforms are totally different. In some cases, they handle the platform itself as a whistleblower. In other cases, the person behind the report. So the main question of our inquiry is who is the one who supposed to be the whistleblower in these cases, because it is not regulated by our national legislation yet. So this was the second pillar of our inquiry, or comprehensive inquiry. And the third and the fourth is also, as I mentioned at the beginning, the special procedure of the National Media and Communication Authority and the Hungarian Competition Authority. And here I have to say that the definition of the body entitled to proceed pursuant to Section 1 of Act on Complaints and Public Interest Disclosure is not clearly defined. So therefore, the Office of the Commissioner has previously applied to the Ministry of Justice for a resolution in this matter. And however, there are also public bodies, sometimes public authorities, whose procedure of handling whistleblower reports is regulated by its own sectoral legislation. They are excluded from the scope of CPID. This is the Act on Complaints and Public Interest Disclosures. For example, these authorities are, as I mentioned, the Hungarian Competition Authority, the National Media and Communication Authority, and also the Hungarian National Bank. Beside this, the CFR, the Commissioner for Fundamental Rights, has the authorization to inquire these organs. So our goal is to put these special procedures on the map of whistleblower protection, and this procedure is also in process. So lastly, I wanted to tell you that unfortunately we do not have many questionnaires sent back yet, but I do hope that by the end of the summer we will be able to evaluate these answers and see how is the whistleblower is protected before the implementation of the directive, and what recommendations should be made for having a properly working system. And we do hope that summarizing these results of the survey in a future report of the Commissioner as a kind of impact assessment can make a significant contribution to the transposition process of the directive, and can also provide valuable information to the legislator. So thank you for your attention.
Thank you, Dr. Baksa. So we may say that we are looking forward to the results of the survey, having another chance to have a conference with your participation. So. Thank you so much. As our session is coming to its end, I will check quickly if we have any questions and answers, but so far there are no questions. Maybe there will be some more questions later on. As we also overrun a little bit our time framework, I would like to thank the speakers for being with us and for sharing with us your knowledge and your experience. Thank you for these enriching presentations, and I hope that you also enjoy the conference and you stay with us. So now I think it's time to hand over the microphone to Dr. Monika Smusz-Kulesza, the moderator of the second session. I hope that Dr. Monika Smusz-Kulesza is ready to take over the role.
Yes, I am ready. Thank you very much.
Yes, thank you.
Thank you very much. So, distinguished guests, ladies and gentlemen, dear colleagues, it's my greatest pleasure and honor to moderate the second session of this high-level conference dedicated to workplace whistleblower protection in the Visehrad countries, France and Slovenia. During the second session, we will have the opportunity to listen to 7 renowned speakers who will introduce us into the issue of improving the workplace whistleblower protection in the Visehrad countries. First of all, I would like to welcome all the panelists from this session to know for sure that all of you can speak and we can hear all of you. So first of all, I would like to welcome Professor Jakub Morawek. Mr. Professor, can you hear us?
Yeah, hello.
Okay, thank you very much. Dr. Iji Kapras. Mr. Doctor, can you hear us?
Sorry, hello, I'm substituting for Dr. Kapras.
Okay, so welcome at the second section.
Thank you.
Professor Peter Varga, can you hear us?
Hello, everybody. Yes, we can hear you and see you as well.
Okay, thank you very much. Ms. Zuzana Dubosova, can you hear us?
Yes, I can hear you.
Okay,
hello,
thank
everybody.
you very much. Mr. Professor Attila Kun, can you hear us?
Yes, good morning. Hello, everyone.
Good morning, hello. Mr. Professor Zbigniew Hein, can you hear us, Professor? Mr. Professor, can you hear us? Professor Zbigniew Hein? Okay, so we have maybe a small technical problem here. Mr. Adam Ożarowski, can you hear us?
Good morning, I can hear you well, thank you.
Okay, so thank you very much. Before we will listen to speeches planned for the second session, I would like to remind some technical issues. So first of all, I would like to remind all the participants that questions to speakers can be put on the option question and answers. They should be written in English or in the native language that the speaker to whom the question is addressed can answer and can read. Those of you who cannot ask questions in English or in the native language of the speaker will be given time at the end of the session and at the end of the discussion, of course, if the time limit allow, to ask questions orally, if, of course, the time frame will allow us to have such a possibility. The panelists, if the panelists want to ask the question, you should write the question in the chat section, as the question and answer option is not available for you. I would like to stress very much the need to keep to the time discipline, because we are exceeding the time. So all the panelists, please take the opportunity to use the time which is provided for you, but please try to stick to the time limit. And I think now, after the small technical issues, we are ready to start our journey with the workplace whistleblower protection in the Visehrad countries. We are going to start with presentations concerning the Czech Republic. The first person who will be presenting is Professor Jakub Moravec. It's my greatest pleasure to introduce new professor. Professor Jakub Moravec is an academic counselor and faculty member at the Department of Law and Social Security Law at the Faculty of Law of Charles University. Apart from that, he is also a member and vice president of the Czech Society for Labor Law and Social Security Law. And additionally to this, Professor Moravec is also an attorney at law in Prague. So it's my greatest pleasure now to give you the floor, Mr. Professor. Mr. Professor, we cannot hear you.
Sorry, it's okay?
Yes, now we can hear you well.
Okay, thank you for the floor. Dear colleagues, first of all, I would like to say thank you, Professor Skupeň and your team for organizing the conference and the whole project. Such it is not easy to pull off even in non-pandemic times. Today, 3 more colleagues from the Czech Republic will be speaking about the current draft legislation on whistleblower protection in the Czech Republic. Colleague from Trade Union, colleague from Ministry of Justice, and colleague from large employer. So much my speech will be really short. Just a quick recap. In September last year, we spoken here with Professor Pichert about earlier legislative proposals for the protection of whistleblowers in the Czech Republic. Among other things, we made it clear that the Czech Republic did not yet have any comprehensive legal regulation on whistleblowing, and that the transpositive legislation was still being prepared. So forward to the present, it's now June 2021. And the Czech Republic still does not have any comprehensive regulation on whistleblowing, and moreover, the transpositive legislation is still being prepared in a certain sense. We have had a parliamentary bill on the protection of whistleblower from Pirate Party. This one was rejected. And this one was then followed by a governmental bill on the protection of whistleblowers. Currently, it's undergoing the first reading in the Chamber of Deputies, and a number of amendments have been tabled as well. You can find a link to the parliamentary publications of all bills in the presentation. And wait a minute, so I take it down in a chat. The governmental bill can be undergo the first reading in the Chamber of Deputies first on 12 July 2021. Then a second and third readings must follow. Then the bill must be discussed by the Senate. Senate can the bill return into the Chamber of Deputies. Finally, the bill needs President's signature. President can too return the bill in the Chamber of Deputies. In short, the bill still has a long way to go. To make things worse, there is an upcoming election this autumn for the Chamber of Deputies in the Czech Republic. As to whether it's realistic to accept that the Czech Republic will catch the transposition deadline in time, what the mechanism of the law is, and what amendments will be probably accepted, a colleague from a Minister of Justice will be inform you about all of this. Colleague Mr. Stransky from Faculty of Law of Masaryk University in Brno, who is active in a trade union for employees in the financial and insurance sectors, will be presenting his view of the bill. And lastly, Patrick Stoniek from our Faculty of Law, who also works at Škoda Auto, will be talking about how the bill has been perceived by employers. Thank you for your attention. Have a nice day, and most of all, I wish you good health. Thank you for your attention.
Thank you very much, Professor Moravec, for this short but enriching presentation, introducing us into the topic of discussion that is taking place in the Czech Republic. And now we are going to listen to another intervention connected with the same country. It will be intervention given by Dr. Iji Kapras. Okay, I'm very sorry. On behalf of Dr. Iji Kapras, Johanna Treslova will be speaking, and the presentation will introduce us into the topic of the transposition of the European Union Whistleblower Protection Directive from the perspective of the Czech Republic. Ms. Johanna Treslova, the floor is yours.
Thank you very much. Thank you for the floor, and thank you, the organizers, for creating such a great platform once again. It is very important to be able to share our experiences here today. So thank you for having me. As some of you may have already noticed, I'm not Mr. Kapras, as he's had a last-minute work emergency, so I will be substituting for him very much like last year. So let me just briefly introduce myself. My name is Johanna Treslova, and I work as a senior ministerial counselor at the Anti-Corruption Department of the Ministry of Justice. And I'm part of the team which is in charge of the transposition, so I hope I won't be much of a disappointment and you will enjoy the presentation nonetheless. So in today's presentation, I will be talking about drafting of the national regulation in the Czech Republic, which is transposing the so-called Whistleblower Directive, as we quite advanced in the legislative process since the last time. So I will bring you up to speed and inform you about the state of play, and then I will be talking about some of the biggest changes that we've had to make during the legislative process. Later on, I would like to talk a bit about some of the complementary non-legislative activities that are aiming to introduce the new regulation to the general and professional public and to promote the whistleblowing in general. So just as last year, firstly, I would like to briefly introduce some of the differences between the Czech bill on the protection of whistleblowers and the directive, just to refresh your memory a bit maybe, and for you to have a general idea about the concept. So probably the most important aspect of the draft law in which we have deviated from the directive for the benefit of whistleblowers is the broadening of material scope. So we took the horizontal approach, as was mentioned before, and we decided to broaden the material scope and include all administrative offenses and or all criminal offenses. Regarding the external reporting channel, as of now, the Ministry of Justice, more specifically one of its departments, is set to fulfill the role of the external reporting channel. As for the protective measures envisaged by the directive, there is a prohibition of retaliation as a general rule, and there are also provisions that constitute the assistance of the Ministry of Justice, which should serve as a sort of a guide to the whistleblowers and the general public as well. We also incorporated a shift of the burden of proof once there is a prima facie proof of a retaliatory measure, and also a court can invoke a provisional measure without the obligation of the whistleblower to lodge a security. An important part of every regulation are sanctions, of course. So in our bill, we rely on administrative sanctions and on civil liability. So as for the state of play, the first reading of the bill in the Chamber of Deputies took actually place on the 12th of May. And the bill is now discussed in the committees, more specifically the Committee on Public Administration and Regional Development and the Committee on Constitutional and Legal Affairs. Unfortunately, the motion to cut short the period for the discussion about the bill in those committees didn't find the support needed. So now those committees have 60 days to discuss it before more deliberation in the plenum will be possible, which will be at the earliest on the 12th of July. So we can only hope that we will be able to finish the legislative process till the end of the term and the election in autumn. So regarding the aforementioned changes, probably the biggest change is the nature of the external reporting channel, which as of now is supposed to be the Ministry of Justice. But the initial idea was to create a brand new authority which would be competent in the area of the protection of whistleblowers. But that quite soon proved to be a very unrealistic plan. So we also considered the possibility that the Ministry of Justice will be an authority that would conduct some kind of at least a preliminary investigation of the wrongdoings reported, but we faced some pushback on this, and we will also have to carry out this new agenda on the current budget. So the final version of the bill views the Ministry of Justice more as a kind of a postman, which sorts the reports out and forwards them to responsible authorities and maintains the contact with the whistleblower. Also, in accordance with the directive, we explicitly excluded from the material scope of the bill the parts of the reports that discloses information that are somehow threatening to the national security or to essential security interests, such as significant security operations, combat capability of the armed forces of the Czech Republic, or the activity of intelligence services. But this really in fact applies only to the information of mentioned nature and does not in any case constitute dismissal of the report as a whole, which is important to say. After some criticism, we also decided to include an indicative list of retaliatory measures, which we at first viewed as a disadvantage to whistleblowers in the judicial practice, but this change was welcomed by various stakeholders, as the list is the same one as the one in the directive, just modified slightly to be in accordance with our legal framework. So the last change probably worth mentioning is enabling the reporting under the scope of the bill to as many people as possible, which in our case means lowering the threshold for the obligation to implement an internal reporting system for municipalities and employers of 5,000 residents and 25 employees respectively. As for the amendments that are known to us at the moment and will be discussed in the Chamber of Deputies, there are proposals to raise the threshold mentioned before, strictly following the numbers set out in the directive. And another amendment proposes to raise the upper limit of the fine for knowingly making a false report. And finally, there is also one proposal to adjust the rules for sharing the internal reporting channels in regards to large corporations, meaning sharing the channels among parent companies and their subsidiaries. Last but not least, I would like to talk about a bit about the complementary non-legislative activities. Because from public opinion surveys, we are very well aware of the fact that the general public isn't very familiar even with the term whistleblower, not even mentioning the legislation concerned. So we felt this was really very important part in order to create really effective whistleblowing system, legal and practical. So this activity in particular is a project called Strengthening the Fight Against Corruption by Increasing General Awareness of the Public, focusing on judges, prosecutors and public administration. It is partly dedicated to the issue of whistleblowing, partly to the issue of conflict of interest, and in the part of whistleblowing, there will be an international comparative study conducted, which will analyze the international practices regarding the protection of whistleblowers, and hopefully help us define some potential blind spots of the approach and treatment of whistleblowers and whistleblowing cases by public servants and offices, and thus should help the public sector with its strategy. And furthermore, it will be used actually in trainings, workshops and seminars targeted at judges, public prosecutors and other public officials. One of the components of the project is also a media campaign that will be targeted on public officials as well as whistleblowers themselves, including introducing them to the legislative framework. Thank you. That is all from me for now. Thank you very much for your attention.
Thank you very much, Ms. Johanna Treslova, for your interesting and comprehensive contribution. Thank you for commenting on the biggest changes of protection of whistleblowers in the Czech Republic. Thank you very much also for sharing your practical experiences connected with the actions that you take, complementing the legislative complementing and supporting the legislative process. Thank you very much for this perspective of the Czech Republic. And now we are going to move to another country, and we are going to listen about the Slovak perspective. I would like to introduce now Professor Peter Varga and Dr. Weronika Zoričáková, who will be speaking and who will be presenting on the Slovak perspective. We are really curious to listen about your experiences connected with improving the whistleblower protections in your country. As we can learn from the abstract that you have sent, there are issues, there are lots of issues connected with the legislative process and with the regulations which are occurring in your country. And there are also some problematic issues. So we are very curious to listen about this topic. So now I would like to give the floor, as I see, to Dr. Weronika Zoričáková, yes, who is a lecturer at the Department of Labor Law and Social Security Law at the Faculty of Law of Prawa University, who will be presenting from the Slovak perspective. The floor is yours.
Thank you very much.
Okay.
I'm very sorry, Professor. No. I'm very sorry, Professor, not for introducing you. I thought that only Ms. Dr. Weronika Zoričáková will be speaking, no but of course we have also on board Professor Peter Varga, who is the professor at the Department of the International Law and European Law at the Faculty of Law of Prawa University. He is the chair of the administrative board of the Slovak National Center for Human Rights, and also and also he is at the National Human Rights Institution in the Slovak Republic. One more time, I'm very sorry for not introducing you at the beginning.
No problem.
It's my pleasure to give you the floor.
Thank you very much. I'm very happy, or we are very happy with my colleague Veronika that we can present the Slovak perspective to you, and we will share the presentation together with my colleagues. So I will start, and then Veronika will continue, and I will tell some problems at the end. So, well, the content of our presentation is about the perspective of Slovak whistleblowing legislation, because there was quite significant change in the last years, and of course, due to the directive, the EU directive, we expect some changes as well. So I will start with the Slovak legislation on whistleblowing. Nowadays, we have a relatively new act from 2019 on the protection of whistleblowers of antisocial activities. So this act is relatively new and replaced the previous legislation that was effective just 5 years. Well, despite this relatively new act is effective as from the 1st of March 2019. It has not been fully applied yet, because there are some issues that are still not applied. And I'm very happy that after our presentation, Ms. Zuzana Dongoshova will continue, and I hope that she will also present what's new in the field of application of this act, because this new act established the Office for Whistleblowers Protection, which is still not functioning, because she was elected just by the parliament in February this year, and there is still 6 months period till she must start her office, and till this time their work inspectorates perform the tasks of the Office for Whistleblowers Protection. Well, in the Slovak Republic, as maybe you can see in the presentation, there is the special act regulating whistleblowing in the Slovak Republic. So the legislation is not divided into a separate act, but there is one special act. Well, with respect to this act, or why there was a change after 5 years of effectiveness of the previous act that was adopted in 2014, was especially that the office was established. Well, with respect to whistleblowing, we must also discuss some social problems, maybe some political problems that exist with respect to whistleblowing. The social problems are maybe, I would say that not, or the unwillingness of persons to notify the antisocial activities. I think this social problem is connected maybe with the history in the 4 countries we have, because maybe of the communistic regime that used to be in our countries, and maybe the people still do not believe that they should notify the antisocial activities, or maybe the other view is how other people look on them, that when they maybe notify such an antisocial activity. So maybe the other people, the rest of society sometimes does not accept that somebody notify the antisocial activities of someone or the employer. Maybe the other problem I mentioned is the political problem, and the political problem is that you can see that as from the March 2019, it lasted quite a long time till the head of the Office for the Whistleblowers Protection was elected. So you can see that there was not a political will to start the new office, that should protect the whistleblowers. And maybe just one sentence to mention is that after the election we had in Slovakia, the new prime minister said that it is not necessary to have such an office because the new government has anti-corruption as the aim. Such an office is not really necessary because it was necessary during the times of the previous government. So you can see that there is also a political unwillingness to support maybe these activities. Well, we also must mention the Anti-Discrimination Act, which is closely connected with whistleblowing, and at the end of the presentation, I will explain why. And of course, we cannot forget the labor law connection, criminal law connection, administrative law connection, because especially the labor laws and the labor code are applied with respect to the employees that may be sanctioned for various reasons, maybe by the employer, due to the fact that they are the whistleblowers. With respect to the directive 2019-1937, I must tell you that this directive has not yet been transposed. Okay, there is still some time, but there exists no draft proposal that we may present today. So maybe in the next presentation we will know something more about the draft proposal, whether it exists or not. Well, now my colleague Veronika will continue with her speech.
Thank you very much. So quite a few words to our problematic personal and material scope of our new act. As you have already seen, the Slovak Republic has a brand new act from 2019. But when you would compare this the new act with the previous act, and as you will see in a few minutes, the new regulation is not that much progressive as it may seem. The definition of whistleblower is defined or is stated in the section 2 of the new act. And basically, pursuant to this act, a whistleblower is any natural person who in good faith reports information on antisocial activities, as long as it's close person, basically working for the same employer. Pursuant to the explanatory memorandum to this act, a whistleblower is any natural person that reports not only crimes or administrative offenses, but any antisocial activities. And a whistleblower is not only employer or worker, but it's also unpaid or paid intern, volunteer, self-employed, subcontractor, but also member of statutory or other bodies in companies. The core of whistleblower protection pursuant to the Slovak Act lies in section 7. This so-called ex ante protection given or provided by the office. This is really strong protection given by the office, because once having the status of a whistleblower, an employer cannot act against a whistleblower, so he cannot affect negatively his or her employment terms or working conditions unless prior consent with such an act given by the office. If the employer does not ask for such a prior consent, the act, the negative impact is invalid. So this is really strong ex ante protection given by the office, but the act has also rather strong ex post protection. So again, once having the status of a whistleblower, if such an act with negative impact was already made against a whistleblower may file for temporary protection and may file for suspension of the effects of such an act. This suspension is valid for 30 days, which is granted also by the office. Why is this problematic, such a personal scope? Because the broad definition of a whistleblower does not fully correspond actually with this material protection given by the office. So overall, please next slide. When we have ex ante and ex post protection, it seems that ex ante protection is only provided to employees and to employees only. Explanatory memorandum to the Act states clearly that only this kind of protection is provided only to employees. So all the volunteers, self-employed members of statutory bodies are not protected by the Section 7. Ex post protection is provided more widely. And does cover all the other types of whistleblowers, not only employers and not only workers. But the problem is with this ex post protection that it's only temporary and quite procedural measure, because the Act in Section 12, with regards to this ex post protection, it anticipates the initiation of main anti-discrimination proceedings. So when you look at the personal and material scope of the Act, it seems that quite the broad types of whistleblower protection is given still not in the hands of the specialized Act, but in the hands of anti-discrimination legislature. Moreover, when talking about material scope of whistleblower protection, the Act further distinguishes between a report or notification of antisocial activity and serious antisocial activity. There are also different statutory consequences as to whether a whistleblower reported antisocial or a serious antisocial activity. What's a serious antisocial activity? You can see on the PowerPoint slide. It's basically more serious crimes and more serious administrative offenses. And what does it mean in terms of given protection? There are different range of protection in criminal or administrative proceedings. Basically, only when a whistleblower reports serious antisocial activities, he or she is provided with protection in criminal or administrative proceedings. Moreover, if a whistleblower reports serious antisocial activity, only then the employer is granted by the strong ex ante protection provided by the office. And only if a whistleblower reports serious antisocial activities, there are certain financial incentives, which means that the office may grant a certain amount of monetary remuneration, as it is and it's a serious issue of public interest, of course. So basically, overall, as you will see in the next slide, the personal and material protection is quite restricted. And quite broad protection is still provided not by the specialized Act, and thus not by the specialized office for whistleblowers protection, but is provided still by anti-discrimination law and by civil courts. What it actually means, now Peter will enlighten you.
Mm-hmm. Well, I will also present the internal and external reporting schemes. What are maybe the employers obliged to do with respect to internal reporting schemes? Well, according to our legislation, the Slovak legislation, the employers must issue the internal rules and must appoint the so-called, we call it a responsible person. It's the translation from the Slovak Act. So the employers must appoint such a person or issue such an internal rule on whistleblowing. If they employ more than 50 employees, this is applied to private entities, and there are stricter provisions with respect to public entities. So these entities are obliged to appoint the person or issue the internal rules on whistleblowing if they employ more than 5 persons. Of course, there are some modifications with respect to institutions that are established by other public entities. So, but With respect to the internal rules, the law strictly specifies what this rule must contain. So usually it's the process, how the complaint, the notification should be handled. Of course, the data protection cannot be forgotten as well, because it's very important in whistleblowing process. So there is a strict confidentiality of the whistleblower during the whole verification process of the report. We cannot forget the anonymous reports that are not recognized by the Act, unlike the previous legislation. But anonymous reports are not at all recognized by the current legislation. Maybe we can have a look at the responsible person. It's I would say the officer in charge of receiving the reports. Such a person is responsible for verification process, informing the whistleblower about the outcome of the verification process, and he or she is responsible for keeping the records of all reports made. The law or the current legislation just says that the person should be professionally capable to perform these obligations, but does not deal with the prerequisite, the conditions that such a person must fulfill. So it may be employee, or it may also be an external entity as well. But such a person should only be responsible, or should get the instructions from the head of the employer. With respect to external reporting, there is not subordination between internal or external reporting. The external reporting is made by a specialized institution, either criminal institutions or administrative procedure institutions. Veronika has already explained when the person, the whistleblower, is granted the protection, and there is a difference between the notification of criminal offenses or those offenses that are serious antisocial activities. So there is an obligation to grant a protection in case of serious antisocial activities if these are reported, and in case of other activities the protection is given upon a request of a whistleblower. We have already mentioned the anti-discrimination legislation. Well, and what is the connection of anti-discrimination legislation and whistleblowing legislation? Is that the Slovak Anti-Discrimination Act contains the catalog of criteria for which the discrimination is prohibited. This catalog is open and includes also the ground of reporting a crime or other antisocial activity. So if somebody is sanctioned unjustified or so this is considered as the breach of anti-discrimination legislation, and such a person can seek a protection of anti-discrimination law. Well, and of course, if anti-discrimination rules are applied, there is the reverse burden of proof in discrimination cases. So that means that the defendant is required to prove that he or she has not infringed the principle of equal treatment. Of course, this should be done within the limitation period of 3 years. Well, I can also tell something about the protection against reprisal measures. So how the whistleblowers, how these employees are protected. So if an action is made against employee by the employer, so what may happen, then what is if the claim for unlawful dismissal, so if the person is dismissed unlawfully, and the Slovak Labor Code says that such an employee may claim a compensation for his or wage. But the step is that before claiming a compensation for his or her wage, the employee must inform the employer that he or she insists on a further employment, and after the court may compensate the unlawfully dismissed employee. Well, with respect to contractors or candidates or trainees, these are not explicitly mentioned, so it's not regulated at all. So these categories of persons have no special claims for compensation. Well, with respect to claims for immaterial damage, this is awarded pursuant to Anti-Discrimination Act, and only if it is inadequate or if adequate redress is not sufficient. So what is also important that the action of the employer must significantly reduce the dignity, social seriousness, or social status of the whistleblower. And if this requirement is fulfilled, then the whistleblower may ask for a compensation for immaterial damage. And of course, it's up to the court that will decide about the amount of such a damage. Okay, so thank you for your attention. And if you have questions, so feel free to ask us. Thank you.
Thank you.
Dr. Varga, Dr. Weronika Zoriczakova, thank you very much for your comprehensive and enriching presentation concerning the Slovak perspective of whistleblowers protection. Thank you for sharing us. Thank you for sharing with us all the experiences that you have and all your interpretations and all your conclusions considering the regulations that you have in your country. And I think now it's time to proceed with maybe not Hungarian law yet, because I think we are going to listen, dear Professor Attila Kun. We have one more person to be speaking now before your presentation. This will be Zuzanna Długoszova, who is the first head of the Whistleblower Protection Office. Who is also a member of the Slovak Bar Association, who worked with several human rights organizations as a trial attorney, as a lecturer and independent expert, and who lectured also for the Slovak Judicial Academy, training judges, prosecutor, and judicial assistants. Ms. Zuzanna Długoszova, the floor is yours. It's my greatest pleasure to give you the microphone.
Thank you very much. And let me thank you, first of all, for inviting me to this conference. During the course of it, as I understood, you started 2020. And as I've been recently elected and became sort of the member of the internal circle, I really appreciate your last minute invitation to include me into the program. So I'll try to share my screen now. Can you hear it now? Can you see it? Sorry.
Yes, we can see it.
Great. So, as my colleague from Trnava University already mentioned, and they provided a great comprehensive explanation of the current legislation, I will not go deeper into the current legislative state, but maybe I would be better placed to share with you guys the expertise how to set up the new state administration office. This is what I'm expert in right now, and maybe not dealing that much with the content of the whistleblower protection, which will come soon, as the office should be functioning as of September this year. But today I decided to share with you and walk you through a little bit of summary of legislative approach and practice in Slovakia, challenges for functioning whistleblower protection in Slovakia, and tools and strategies how to overcome those challenges. A little bit of consideration how to measure our impact, how to measure our success. And then a few words, as Mr. Varga already mentioned, that we have not much information about the transposition of the Whistleblower Protection Directive. I have a little bit of information, so what I have, I can share with you. And if you may ask, what's the picture I have on the first slide? I decided to share the picture I really like very much. This is a statue of ethos in the city of Canberra in Australia. And I think this figure of ethos represents well the topic of our conference today, because according to the author Tom Bass, this winged figure of ethos represents the spirit of community, and the sun, which is holding the statue, represents the culture and enlightenment. And I think both culture and enlightenment and spirit of community is actually what we are discussing here today, because we discuss how to better assist those who help the community and help to protect the public interest. So this is just a little bit of introduction to how I perceive the topic. Concerning the legislative approach and practice in Slovakia, as you have heard, Slovakia has taken quite a speedy and progressive steps in introducing whistleblower protection legislation. You have heard that we have had the legislation since 2014, and despite the existence of the whistleblower protection law and the labor inspectorates, which was the body designated to collect and provide reports and provide protection of whistleblowers, the labor inspectorate themselves informed between 2015 and 2016 only about 32 cases of protection granted by the prosecution service or labor inspectorate. So despite more than 6 years of existence of a certain formal system of whistleblower protection, we have not seen much of an impact, and we also see that there is a relatively low knowledge and awareness of the whistleblower protection in Slovakia. And this leads me to the conclusion, as it applies in many other areas, that people are the most important system component, or that as a professor from Slovenia mentioned, that the legislation is not everything, that implementation is really crucial, and that it matters whether dedicated people in public offices, businesses, civil society, and other communities will care about the issue, because it's not only about applying and adopting the legislation itself. We were discussing and reflecting upon the situation, why there is rather a very low willingness of individual to report corruption or other breaches. And from the existing data, we have concluded, or we can see that there is pretty low trust in law enforcement in Slovakia. And although I am the new whistleblower protection head, I might have a tendency to boost around about the importance of our office, but I don't think the office is the most important element of helping the whistleblowers, because I think the trust in police and prosecution service is really, really crucial. And we see from the existing data that the trust in police, for example, in Slovakia, is among the lowest in the European Union countries. Another challenge is fear of persecution or job loss, like the typical consequence and fears of whistleblowers. Poor knowledge about the existing legislation, legislative protection, and then already mentioned strong post-communist country perception of those who report wrongdoings as snitchers or those who inform. We know that we had the secret state police in our countries, and these informers were actually not doing well to their communities, but the opposite was true about them. And this kind of label is still carrying the whistleblower protection in Slovakia, in Slovakia's eyes perception sometimes. And then another challenge is the well-embedded mentality of passive approach to issues of public interest. We have a saying in Slovakia which goes, "Nehas čo ťa nepáli," and I was trying to find some equivalent in English, and I found what you can see on the screen: "Let sleeping dogs lie, leave well done." If everything is fine, why not? Why to fix it, etc. So this passive approach is something that leads the people not to believe that actually they can. By reporting, they actually change their community for better because they only see the negative image of those who actually then face severe consequences after reporting some violation. And then another challenge is the quite wide-ranging tolerance for not respecting rules or mental reservation about the state authorities in general. Our Czech colleagues and Slovak people know another saying: "Those who don't steal are stealing from their families." So this is all a mixture and the starting point at which we start our activities. And of course, we have to make some consideration about the situation which we face socially. Despite the not ideal situation, of course, we are thinking about the tools and strategies we might apply. And the biggest challenge for me is how to shift the perception of whistleblowers and whistleblowing to make the society recognize that whistleblowing is actually as an act of socially responsible behavior. What we plan in our office is the widely visible campaign. Not only about the existence of the whistleblower protection and the new whistleblower protection office, but also about the negative effects of corruption on the society, so that people feel responsible and feel motivated and feel that this is okay to join in and to be active. This is under our control. The other goal, to increase public trust in police and prosecution service, is not that much under our control, but despite that, we in our office, we would like to create some type of partnerships, educational activities with the police and promote their good work in order to increase the public trust. Because if there will be trust in the police, also the effect of the whistleblower protection will be seen on cases that there might be solved successfully by the police. So we would like to make the police understand that we can be actually we can have mutually useful cooperation, and in some situation we can also do some filtering for their work and just send the cases that are really really crucial for their work and for their further investigation. And of course, we would like to keep our eyes and ears open and analyze other challenges, regular opinion surveys, focus group discussions to understand why there is a certain phenomenon in our country. And also regular data collection from employers and public institutions. This is also crucial to understand the environment, to understand where are bigger issues to be focused on. Another question we are asking ourselves is how to measure our impact, how to measure our success. There is always a situation when there is a new office about the people legitimately might ask, do we need the new office? How much will it cost again? etc. So we would like to be accountable and also see impact of our work. What we would like to start with in really measuring some type of our activity and some of our successes is to measure the recognizability of the Whistleblower Protection Office and measure the awareness about the existing protection, follow the trends from the start in 3 years, how this will change. As I mentioned, the public opinion polls and focus group about discouraging factors for potential whistleblowers. So knowing the data, then we can aim also the communication strategy for the public. And of course, regular collecting data according to areas in which protection was sought or granted. So these, another area which some might ask is like whether we will measure also cases. I think we will be measuring cases, and we will count how many cases they were sent to the police and how many were successful and how much money we saved. But I think this is too ambitious to ask during the first 2 years of the existence of the office. So I honestly declare that I don't really am ready to measure the success of the Whistleblower Protection Office according to the number of successfully solved and investigated cases. I hope for it, and I hope that this will be the result in the long run. And last but not least, transposition of the EU Whistleblower Protection Directive. We have learned recently that the Office of the Prime Minister is actually working on the draft to amend the existing legislation. We must say that we have quite an extensive legislation already, but in terms of personnel and material scopes, as my colleague mentioned, it is not sufficient, and the existing legislation will have to be amended. Only briefly, because the work is in progress still, so there is no official draft out there. I only saw some first draft, unofficial, not final wording, so it would be not really serious from my side to share those details because they can still change from one day to another. But I can share the information with you that the draft amendment specifically mentions protection of persons covered by Article 4 of the directive. So there is a plan to amend both personnel and material scope of the directives. There will be definition of retaliation measures that would be more concrete, more precise rules of employers' obligation, including time frame to provide feedback and acknowledgement of the receipt of the report. Basically, I think the approach is to look really into detail of the wording of the directive and see where we are still like either too vague or not really covering what the directive covers. So I hope we will be able to transpose it by the deadline. The plan is to start the legislative process in September. It should be approved by the cabinet. That's the plan, and then it goes to the parliament. So we will see, but there is a realistic chance that December will be fine. And some last remarks, because I don't want to steal time from other speakers. As the legislation is now open, of course, we are also trying to think what other loopholes there are, what other measures can be improved in order to make the protection effective. One of the ideas, still just an idea, we don't know whether we'll be successful in it. We would like to shift the competence to issue effective interim measure to prevent dismissal, because this is the competence of the office to issue an interim measure if a whistleblower received a dismissal from the employer. And then afterwards, the whistleblower can turn to court to ask for another interim measure and to a final decision by the courts. So we would like to actually make the process smoother and just evade this interim stage to turn to the office first and to then turn to the courts. We would like to discuss with the Ministry of Justice whether it wouldn't be better and for the whistleblower protection just to leave the competence to the courts only. And then, of course, I'm thinking also about the fair balance between the whistleblower protection and employers' legal certainty. As you can imagine, the labor law disputes can last really many, many years. Since the protection of whistleblowers in Slovakia is pretty strong, as we issue the interim measure for the whistleblower, the employer has the obligation to pay salary during all length of the legal dispute, which might be really sometimes overburden for the employers. So that's why we would like to discuss with the Ministry of Justice also about possible extra deadlines to finish some types of the legal dispute connected to the whistleblower protection for the sake of legal certainty of the employers, because I think it's not only about protection of whistleblowers, but also about the fairness for the whole community. And if we put the burden that it's too big for the employers, then the cynicism and skepticism about protecting whistleblowers may grow bigger. And this is what we would like to avoid. Thank you for your attention. And this is, if the organizer will share the presentation, this is a piece of poetry which I'm not going to read, and which accompanies the statute of ethos as the final remark. Thank you.
Ms. Zuzanna Dugoszowa, thank you very much for your input into our discussion, completing the vision, completing the picture of whistleblowers' protection in Slovakia. It was really enriching to listen about the challenges of whistleblowers' protection and about the practical issues and the plans connected with this topic from the perspective of the head of the whistleblower protection officer. Thank you very much one more time. And now I think we are ready to move to another Visegrad Group country and try to look at whistleblower protection from the Hungarian perspective. It's my greatest pleasure and honor to welcome Professor Attila Kun, who is the Professor of Labor Law and head of the Department of Labor Law and Social Security at the Karoli Gaspar University of the Reformed Change in Hungary, and who is also a part-time scholar at the National University of Public Service, the Department of Human Resources, and a member of Hungarian Academy of Sciences, and the national coordinator and member of the Hungarian Labor Advisory and Dispute Settlement Service. Mr. Professor, the floor is yours.
Thank you very much, and good morning again to everyone. I hope my slides are visible now.
Yes, we can see it.
Yeah,
yes.
Thank you very much. Thank you very much. Of course, I don't want to repeat, or of course, I would like to repeat that it's a pleasure to be part of this research and learn from each other in the framework of this Visegrad Fund project. And let me share some thoughts about whistleblowing in Hungary. Of course, I should start by saying that as of today, there is no official publicly available draft as regards the transposition of the whistleblowing directive into Hungarian law. My dear colleague Zuzanna has already mentioned this fact. Of course, we have some informal talks and speculations and knowledge that it's underway, it's under preparation, but it's still not official and still not publicly available. And in this regard, it's important to note that in June 2020, the government adopted the new midterm national anti-corruption strategy. And it was just 1 year ago, and the whistleblowing directive was already there, but it was no reference in this document to the reform of whistleblowing, which is kind of special and strange in this context, because in Hungary, as in most of the other countries, whistleblowing is understood as part of anti-corruption. So given this background, I can only talk a little bit about the past, about the quickly passing present, and a little bit about the uncertain future. So this will be the structure of my presentation. Let me start very briefly with the past. The first whistleblowing law in Hungary is from 1977. It was still under the previous state socialist regime. And of course, it was in the name of the socialist morals, but it was already about public interest disclosures. I should mention that this is the Hungarian terminology, so we don't really use whistleblowing in public terms and in daily use, but the expression, the terminology of public interest disclosure is mostly used. The second important piece of legislation happened in 2009. We call it the Fair Procedure Act, which was a quite progressive act in terms of whistleblowing also. This law intended to establish a standalone agency, a public procurement and advocacy authority, to increase the combat against corruption, and whistleblowing would be also part of this, but this agency has never been created, so this law was completely only on a law in books and not in action, full lex imperfecta, but as a source of inspiration we can still use it because it contained many progressive elements in terms of whistleblowing, like incentivizing the whistleblower, some progressive rules about the publicization of the decisions of the authorities, and it contained also very detailed rules on the protection of whistleblowers, what we don't really have now. I will come back to that. If we are nearing to the present situation, of course, we have the currently effective law on whistleblowing. As I said, the official terminology in Hungary is about public interest disclosures. So we use the acronym for this law from 2013, CPID, Complaints and Public Interest Disclosures, Act on Complaints and Public Interest Disclosures, and it's still in effect. And I think it's only my personal opinion that there is no need for a separate new law when transposing the directive. It would be enough to amend and reform this law, this CPID. Already in 2015-16, there were some plans for a new law, also from the governing party and also from the opposition. I mean, the opposition parties initiated a motion, a draft new law, and also the government in its draft anti-corruption program recognized the shortcomings of the currently effective rules of whistleblowing and also the ineffectiveness of the system. That was because mostly of the European semester's reports, because some reports of the European semesters criticized anti-corruption strategies and whistleblowing also in Hungary. Of course, NGOs, as always, are very critical about the currently effective legislative framework of whistleblowing in Hungary. For example, some NGOs filed a submission to the Special Rapporteur of the UN on the promotion and protection of the right to freedom of opinion and expression in 2015. And the summary of this submission was that the current law, I mean the CPI, the Act on the CPID, it does not provide sufficient protection to whistleblowers and has to be reshaped fundamentally, even without regard to the directive, to the new directive. Let me tell some words about the present, I mean about the Act on CPID. We all know that the directive, the whistleblowing directive, foresees a kind of three-tier system of whistleblowing: internal, external, and public disclosures. As regards internal whistleblowing in Hungary, it's fully optional now. But if it is set up, I mean, companies, employers are setting up some kind of an internal whistleblowing system, it must comply with some basic requirements of the law, and it should be published openly on the website on the company. But in practice, it's not really working, I can say that. According to some surveys, only like 29% of companies do have any kind of ethics hotline or whistleblowing channels. And as one research concludes, the standards of combating corporate wrongdoing in Hungarian-owned companies is very much below the international standards. So this is more like a sociological research, not a legal research, but it's kind of telling. As an alternative, as regards internal whistleblowing, we have, according to the German example, the so-called disclosure protection lawyers. Again, there is this possibility for employers to enter into agency contracts with lawyers specialized in receiving disclosures, but it's really not widespread in practice. As far as I know, in Budapest, which is a big city, there are only 2 or 3 lawyers dealing with such a business, this kind of a business. As regards as regards external whistleblowing, I don't want to go into too much details because my dear colleague from the Ombudsman office was talking about this a little bit in the morning. But basically, there are 2 tracks of external whistleblowing in Hungary. The first is a very fragmented system because the competent body, each competent body, I mean the body entitled to proceed in the specific matters relating to the concrete complaint or public interest disclosure, are entitled to proceed. So it's a very fragmented and let's say dysfunctional system, as it was described in the morning. In some public organizations, these channels are working, but it's really not widespread. And in my opinion, the most important channel for whistleblowing in Hungary is the so-called protected electronic system for public interest disclosures operated by the Commissioner for Fundamental Rights. This is there, this is existing, this is operational. The statistics are showing that it's really working, but according to many professional opinions, it's more like a formal way of reporting, because the Ombudsman's office has not much empowerment and real capacities like institutional, administrative, human resource, and other capacities to really conduct substantive investigations. So this should be really improved, in my opinion, with the new draft law. The weakest link of this 3-tier system is the public disclosure, because we don't have specific rules on public disclosure in the currently effective legislative framework. In the Hungarian whistleblowing law, probably the weakest point, the shallowest point is about the protection of whistleblowers. We have a general clause, a very flexible, very broad general clause in the law about protection. You can read this on the slide, which reads as follows: any action taken as a result of a public interest disclosure which may cause disadvantage to the whistleblower shall be unlawful, even if it would be otherwise lawful. So this is a very general clause, but apart from that, there are no specific remedies institutionalized for victimized whistleblowers. I'm a labor lawyer. From the point of view of labor law, I can tell you that reinstatement of unlawfully fired whistleblower would be almost impossible under Hungarian labor law, because reinstatement is not a general sanction in Hungarian labor law. We are focusing on compensation, financial compensation. So this is just an example, but this kind of targeted specific remedies would be needed. And also we have this ban on retaliation, but there is a lack of specific means to protect whistleblowers from reprisals, from criminal prosecution, and even from civil actions. Connected to this general clause, there is a unique category in the Hungarian whistleblower law. We call it whistleblowers at risk. So there is the specific category in the law that there is a chance to qualify some whistleblowers as whistleblowers being at risk But this is again a lex imperfecta because it's not clear that who is competent to clarify the whistleblower being at risk, and it's also not clarified that what kind of aids and what kind of protection could be awarded to this specific category of whistleblowers. So again, as I said, this is kind of a weak point of the Hungarian whistleblower law. I already touched a little bit upon some labor law issues connected to this topic. Let me start by saying that the reversal of the burden of proof is not clearly institutionalized in this regard. With some creative interpretation, we can come to this conclusion that is there, but I think, and also in line with the directive, it would be useful and sensible to make it clear. I mean, the reversal of the burden of proof. As regards the role of workers' representatives, we can say that maybe works councils could have a say in setting up internal whistleblowing systems, but again, it's not completely clear in terms of labor law. So this could be or should be clarified to some extent. Also, the confidentiality rule of labor law as regards business secrets is very objective, very absolute, and the CPID does not clearly set aside this duty. So maybe again, this would be an important point to make it more clear in the upcoming new law. And one more point about labor law. As one research says, that even the best constructed whistleblowing system will remain ineffective if it is not used by employees. Of course, it's a sociological fact, but in terms of labor law, there would be need for specific targeted information and drivers for employees to use the whistleblowing system. And of course, currently we do not have such rules. And let me talk a little bit in the last part of my presentation about the future, which is, of course, as I said, uncertain because we don't have a publicly available official draft. But it is obvious that certain reforms are clearly needed in the light of the new directive. Let me just mention the most important ones very briefly. The Hungarian law has a much more restrictive personal scope than the directive has. So definitely, there would be a need to broaden the personal scope. I mean that former employees, contractors, prospective employees should be included in the personal scope. As regards the material scope, maybe this is the trickiest point, because we all know that in the directive there is the annex, and the protection applies only to some specific subject matters of EU law. And as I see, there are two choices for the Hungarian legislator, whether to narrow down the material scope to the according to the annex of the directive, which would be very bureaucratic, in my opinion, in practice, or as it is currently now. Currently, we have a very broad material scope, unrestricted, more or less, not unrestricted, but not very specified. If we leave it like that, of course, it would be kind of a progressive implementation of the directive, but maybe it would be too broad and too undefined. So it's a big choice, in my opinion, for the legislator to decide which way to go. Some other things. Certainly, there will be a need for more detailed specific rules on the prohibition of retaliation. As I said, we only have this general clause. Reverse burden of proof was already mentioned. It needs institutionalization. Also, there is the need for the obligation to establish internal reporting channels in the private and public sector. We all know that this is one of the most important novelty of the directive, and this is just optional now in Hungary, so we have to create this. We need rules on public disclosures as an ultima ratio, because we don't have that now. And of course, there is a need, a ban on waiver of rights and remedies. That would be especially interesting in terms of collective agreements in Hungary, because collective agreements basically deviate from statutory rules in all kinds of direction and in every regard. So that would be important to make it clear that there is no chance to waive the rights and remedies connected to whistleblowing. And of course, the directive foresees effective, proportionate, and dissuasive penalties, which need to be created under Hungarian law. As I said, we don't have official information on the draft, but let me be a little bit subjective now, and let me share you with some personal guessing, some personal speculation about the possible ways of implementation of the directive in Hungary. So what I will tell now, these are just very intuitive predictions, of course, not official statements, but I would like to say 5 points. First, in my opinion, the transposition of the directive will be minimal. I mean that most labor law directives, social law directives, of course, whistleblowing is not a genuine labor law directive, but it has some connection to employee protection. And in this field, it's a general trend in Hungary to have a minimum compliance with the directive. So I think that the same thing will happen with the whistleblowing directive. Second, the new labor code had in 2011 it was created as a main policy priority, the competitiveness of the national economy and the minimalization of bureaucracy on employers. So in this framework, in this regard, I think, again, it's just a subjective speculation that the internal whistleblowing system again will be minimal, just to tick the box of compliance with the directive, and especially for sure there will be an exception for small and medium-sized companies and so on. So until competitiveness and minimalization of bureaucracy is the leading policy goal, this is kind of obvious. Third, I think that the legislator, again, it's just a subjective thinking, can and should build on the existing structures. We have whistleblowing laws for ages now, as we have seen. So I think that the protected electronic system of the Ombudsman Office should be built on and further developed, and also the system of the disclosure protection lawyers is a good way forward, and it is quite sensible for the legislator to build on these already existing and operational system. Fourth, as a labor lawyer, I must say that social dialogue is marginalized. There is no, and I think that there will be no broad social dialogue on whistleblowing, which is kind of painful and sad. And the labor law specialization, I mean, the modification of the labor code is again a tricky and sensitive issue. So I think that these rules will be implemented not from a labor law perspective, but in a specific law. Last but not least, sanctions in the Hungarian legislative framework. We have basically quite soft sanctions. I know it's a generalization, but let me be brief. We have basically soft sanctions, for example, in terms of labor inspection. And even though the directive foresees strict sanctions and persuasive sanctions, I'm not very optimistic in this regard. So these are only my personal estimates and speculations about the future. Conclusions, as we all know, we are still waiting for the draft, and because of that, let me just conclude with some more sociological than legal remarks. I would say that in Hungary, there is a strong preference in practice for anonymous reporting. And in this regard, we all know that the directive is not very helpful. I mean that the directive is neutral in this regard. So again, I think that the directive does not help much in this regard. Also, currently there is a possibility for anonymous reporting, but it's not very protected and very effective. Secondly, it was mentioned by many of my colleagues during this morning that implementation and transposition of the directive is one thing, but the functionality of whistleblowing is another thing. And we all know that the functionality of whistleblowing depends on many other factors beyond the regulation. And the embeddedness of the rules in the organizational culture of Hungary employers is a big challenge. Even if it will be mandatory, we can only be optimistic in the very, very long run, I believe. And as a real final sentence, let me just say that in my opinion, it's again just a personal opinion, no matter what legal framework on whistleblowing Hungary has or will have after the implementation of the directive, there are some specific cultural aversions, organizational and structural barriers, and the widespread poor legal enforcement practices, especially in the field of labor law. So these barriers will here to stay, even if the directive would be implemented perfectly and without any flaws. Thank you very much for your attention.
Professor Attila Kun, thank you very much for your input into our discussion and sharing with us the results of your research. On the whistleblowers protection, thank you for sharing the Hungarian perspective and for stressing the doubts connected with the interpretation of Hungarian regulations. And also thank you for enlisting your expectations connected with the implementation of the directive. Now I think it's time for the representatives of the last Wyszehrad Group country of Poland to add to the discussion concerning whistleblower protection. I'm honored to welcome Professor Zbigniew Hein with us. Professor Zbigniew Hein is the head of the Department of European International and Collective Labor Law. At the Faculty of Law and Administration, he is also the retired Supreme Court judge, and it's my greatest pleasure to give the floor to you, Mr. Professor.
Thank you, Mrs. Chairman, and thank you for giving me the voice. I'm pleased to welcome all the participants. I will speak Polish today, so I've got a headache from the morning, and it would be easier for me to eat what I want to say in Polish. Okay, it's time for changing and proszę Państwa,
ladies and gentlemen, the subject of today is the personal scope of protection of whistleblowers. There are many issues, many problems, therefore I will limit myself to only some aspects which seem to be more important and which somehow lead to divergent opinions. First, let's take a look at the issue from the perspective of the purpose of the directive. The directive is called on the protection of persons notifying violations of EU law, but it is always worth reading the first article of every directive to see what it is all about. Well, it is about protecting and enforcing of union law and union policies. So it is about protecting public interest, which is also our interest for EU law to be enforced correctly. So the protection of whistleblowers is the mean which takes us to this purpose. Why am I stressing that? Well, it is important because any doubts that might occur as regards the definition of the personal scope of the directive, they should be seen and interpreted in the light of this purpose. The second element, which stems from the Article 1, well, this indicates the necessity to well, we are talking about protection of reporting people, persons reporting breaches of union law. However, we know the directive is also protecting people who are somehow close to whistleblowers. What is important from this point of view is that the protection of whistleblowers is an indirect outcome of the directive and the purpose of the directive, and the people close to whistleblowers and their protection is connected with the protection of whistleblowers. So the protection of people close to whistleblowers aims at protecting whistleblowers. And this is also important for the interpretation of the directive, because
zakres ochrony przydzielonej.
We have to assess the scope of protection granted to those who have a relationship with the whistleblower should be assessed from this point of view. So we are dealing with direct protection. This is the protection granted to whistleblowers, and as regards the protection extended to people who have, because of their relationship with the whistleblower, we are talking here of indirect protection. And these are the two notions that we will be referring to. Moving on to the next slide, the next issue is that the distinction between direct and indirect protection is of importance because direct protection granted to whistleblowers is broader.
Zgłaszanie.
This is granted by these articles that allow to notify breaches through internal and external channels, and all the procedures that guarantee anonymity of the whistleblower's identity, and also the provisions on retaliation. However, indirect protection limits itself to the right to enjoy protective measures in some specific situations, protective measures against retaliation. Also, as you can see, the protection of whistleblowers, I mean, the definition of the personal scope takes place through an indicative list. And people covered by direct protection, they are quite numerous, and I would say that it fulfills the majority of wishes that were expressed before that, because it covers not only employees, self-employed, freelancers, volunteers, shareholders, contractors and subcontractors. It's very broad. But if a member state wanted to add a category of people to this list, it is welcome to do so, but it cannot limit it, make it an finish list, because every person who is a whistleblower and fulfills the conditions should be covered by the protection. So even if you add somebody to the list, does not allow a member state to have an exhaustive list. As regards indirect protection, however, the situation is slightly different. We have here a very rich list, but it is an exhaustive list. So there are no reservations that at least the people enumerated here should have the protection. So the purpose may be not to encumber employers too much or other potential offers of infringements of the rights of the signatories. There are, of course, proposals to enlarge those lists. Different organizations and the legal doctrine is suggesting to make these lists longer. And I'll have the next slide, please. Let's move on to the direct protection. And the first issue is the notion of the whistleblower. The directive is not using the word whistleblower. It is talking about a reporting person. Maybe it's that the notion of whistleblower cannot always be easily translated into other languages. This may be the reason. Besides, looking at it broadly, a whistleblower is somebody who informs about some irregularities in an organization, hoping that this way this will be eliminated, these irregularities will be eliminated. Please note that this definition of a whistleblower in the directive is more narrow, more limited. It says that it's a natural person, so there is the first limitation, who reports or publicly discloses information on breaches acquired in the context of his or her work-related activities. So this is a restrictive definition. Does it mean that everyone who fulfills the requirements provided for by this definition is automatically protected? Well, no. We may have a whistleblower who is covered by protection, and we may have a whistleblower who is not covered by protection. For a whistleblower to be protected, it has to fulfill, he or she has to fulfill further requirements defined by the directive. And on this slide, you have complete list. At least I tried to prepare a complete list of conditions that the whistleblower has to fulfill to be considered to be a whistleblower covered by protection. It has to be a natural person, like I've said, who is reporting or publicly disclosing information on violations in the context of his or her work-related activities. Another issue is that the reporting person is reporting breaches that go beyond his or her interpersonal conflicts. So it's a question of public interest, and I will go back to this later. A whistleblower is also someone who is not paid whistleblower. So in order to be protected, you cannot be a paid whistleblower. So if you are on the list of registered or paid whistleblowers, so then you are not a whistleblower who can enjoy protection. Another question arises here is whether there is an obligation to report. In the Polish law, an employee is obliged to take care of the good conditions, working conditions, and the place of work and so on. He or she is therefore obliged to inform about any irregularities. So it is a very broad obligation, and it does not mean that it is a paid whistleblower. So it does not mean that this person will be deprived of protection when whistleblowing. And finally, this person needs to have reasonable grounds to believe that this information is true at the time of reporting and that it falls within the scope of the directive. So this is the good faith issue.
I w konwencjach międzynarodowych.
International conventions. The case law of the European Court of Human Rights. It is stressed that a whistleblower should act in good faith. So this is an adopted standard, but it also shows that it somehow facilitates the situation for employers who may apply retaliation, and simply they may defend themselves before the court, because the good faith depends on proving and showing the motivation, the beliefs. The British law or Irish law uses the notion of reasonable grounds. This is a more objective instrument. So objective grounds, exist depending on the motives behind the action of the whistleblower. An objective observer may say that these were reasonable grounds to believe that this information was true, and we do not have to explain what were my beliefs. We don't have to explain it to the court. This seems to be a very good solution, which was also adopted by the directive. A few words about this notion, which may raise some doubts as well as regards the definition of this whistleblower. What does the work-related context mean? It seems that it is explained in the directive, that is this means current or past work activities, and in a Polish version actually we have a mistake because it is talking about current or future work activities. Well, past is much more logical. So current or past work activities of the reporting person, regardless of their nature, through which he or she acquires information on breaches and could suffer retaliation if reported such information. So this notion of work-related context is not fully clear for me, and I would like to say it more in a more simple way, that this person acquires information in the circumstances related with his or her work, which maybe would sound in a more clear way. And in fact, this is what this is all about. And I checked in the dictionaries that this might be the synonym of this notion in the circumstances of work. Another issue arises here because we have the notion of the work-related context, which is also presented in the definitions of the directive, which means that every time that the directive is using this notion, this should be understood as defined in the directive. For example, if the directive defines the facilitator as the person who is helping the whistleblower in the context, work-related context, it means that it is helping in the work-related context of the whistleblower and not the facilitator's work. So there are some doubts. I do not have the time to develop that. And as regards this notion of the work-related context, it might have to be explained. Maybe the ECJ will have to deal with that.
Dobrze, teraz tak, kwestia rysu.
So, interpersonal conflicts. We should ask ourselves, does the whistleblower have to act in the public interest in order to enjoy protection? Because the classic notion of a whistleblower is that he or she acts in public interest, for general interest or social interest. So we have to ask ourselves this question. Because if we read this very lengthy preamble, many points of this preamble, many recitals of it raise this issue. So it is not something that is irrelevant. And even though the directive under many recitals is stressing
przedstawianie informacji w publicznym interesie i tak, jakie to jest.
That this whistleblowing means presenting information in the public interest and how important it is for the EU. At the very same time, with one exception of public disclosure in such situations, like connected with public security, where without using internal and external channels, you can notify things directly. This is one exception. So outside of this one exception, the directive does not consider action in the public interest as a condition for whistleblower protection. So what does it mean? Well, it means that you can only notify your own private information that is of no public interest? Well, no, the directive, but not in the text, but in the recitals, gives different examples. For example, the example known from the Irish law, or at least a very similar solution to the Irish solution, because the directive stresses that the complaints or the notifications which concern different interpersonal conflicts or grievances, this should affect exclusively the reporting person, and this can be channeled to other procedures, as the recital says. So it is a very good instrument because it's a very simple solution, because once you start pondering what is public interest, then case by case we are analyzing whether we are dealing with public interest as an important motivation for action or not, and there are entire books written about public interest. But we have this very simple instrument which says that if you acted only in your private interest, you are not enjoying protection. But if it does not concern your personal situation, then you can enjoy protection. So this instrument is simple and it's understandable for whistleblowers, because they don't have to ponder whether I report a breach, will it be in public interest or not, and I'm not sure, then I will not report. Well, no, it's a simple instrument understood by each and everyone, and I think that this is a very good solution. So let's move on to indirect protection. I'll have the next slide. This is regulated by Article 4 of the directive, and which enumerates categories of entities that enjoy indirect protection. So this is the protection that a whistleblower enjoys. So this is the protection against retaliation that might also affect people who have some kind of relationship with the whistleblower. So this protection is granted to facilitators, third parties, and the so-called legal entities. And I'll discuss it further on in detail. Let's discuss the third persons. Well, these are the people who are somehow connected with the reporting person. These may be colleagues from work, family members, working, for example, for the same employer, or they are somehow through their professional activity connected with the same employer, and we understand how the retaliation can also affect them in order to eventually hurt the whistleblower. So these are different, and the legal entities are those that the reporting persons own or work for. So you may, for example, refuse this company the possibility to provide services, or enter this company on the blacklist. I think the most numerous group are the facilitators. They are also the first to be listed by the directive, and the facilitator is a natural person who assists a reporting person in the reporting process in a work-related context. There is also a broadened protection that facilitators enjoy because it does not limit itself to protection from retaliation, but it also covers the obligation to keep their identity secret. And here some problems arise. For example, whether civil society organizations can be recognized as facilitators. Well, no. The directive clearly says that this has to be a natural person and in the work-related context. So, in the work-related context of the whistleblower. Trade unions, as such, not as legal entities, but as regards trade unions, their representatives can be whistleblowers themselves, or they can be facilitators, and then they can enjoy protection granted by the directive, but also enjoy the trade union protection. So the question arises whether trade unions and civil society organizations can be whistleblowers themselves. It is often proposed for legal entities to be whistleblowers. Well, in light of the directive, it is not allowed. We can say that, but the question at stake here is whether it might be good for them to be whistleblowers. Well, maybe, yes, it would be good, but in the directive, in the light of the directive, it is not possible, not when using the tools stemming from the directive. In order to be a whistleblower, for legal entities to be a whistleblower, a separate act should most likely be enacted if such a need occurs, where the right measures, the right instruments adapted to such legal entities would be adopted. So who else should be protected? Here we have a few important issues. First of all, people who are believed or suspected to be whistleblowers should be protected. This is being sought as well. Secondly, people who intend to make a whistleblowing report should be protected, and people who attempt reporting. So the question arises whether these people should be also protected. Based on different research, it is being indicated that these people can also be subjected to retaliation. They may be persecuted. They may have may suffer from anticipated retaliation. For example, we suspect that somebody wants to report something or has the intention to report something, or we suspect that this person
to go zwolnimy z pracy.
Intends to report something, then we fire this person, or we move this person to another position in order to prevent it, or to make this person know that it's better for him or her not to do that. And if this is the case, then the protection is necessary. Such people quite frequently can be the victims of such persecution. So the directive somehow takes it into account, because under Article 23, it says that when you try to prevent someone from reporting something, this is banned and this should be sanctioned when you hinder or attempt to hinder reporting. But I don't think this is sufficient protection. How can you grant this sufficient protection? Well, member states can do that, but how can you do that? Well, you can introduce a general rule that somebody who is believed or suspected to be a whistleblower cannot suffer from retaliation in the work-related context. This should be somehow written in a clear way. However, I cannot imagine for a court of law, in case an employment contract is terminated, and then the employee says he was dismissed because he was suspected of being a whistleblower, not to take it into account. The court will take it into account. However, I think it would have to be stressed somehow in an act of law. We might also say, like in the case of people who have a relationship with whistleblowers, that measures, protective measures against retaliation can respectively apply to such people as well. So it is a clear problem which should somehow be solved. And the last issue. For the protection alone, well, law means obligations. So I'm saying that in the sense that talking about rights and not talking about obligations of other people who are to respect these rights does not make sense. So it's really important when talking about the scope of protection to say a few words about who is obliged to protect and to follow the rules on protection. And there are several entities listed in the directive. These are different entities who have to fulfill the obligations connected with the operation of external and internal channels, supervision, coordination, provision of support measures to protected people, and also these duties also relate to prohibition of retaliatory measures. I will not discuss it in detail, but I would just like to say a few words about a very important entity, which is defined in the directive by this term, the legal entity. Well, what is it? What is it? The directive does not apply the normal terms that you usually apply, natural person or a legal person, but it talks about a legal entity. And this may be the equivalent of a legal person, but this is also applied in the EU terminology to mean broadly the subjects of law. Directive is alternatively using the notion of the legal entity and organization. So the organization is more often used in this personal meaning, a legal entity in the material, but the legal entity appears in the material. So linguistically speaking, it's maybe not the most appropriate formulation. It's the same in English and in Polish. So what is this legal entity? Well, it is not possible for the legal entity to be an individual having a legal personality or being an individual. So these can be other entities, organizational entities, that have some kind of autonomy under the law, but they may not have the full legal personality. So this could be a unit which is an organized whole, having its direction, having its tasks, a group of people working for it or working with it, civil workers and others, subcontractors. So the idea behind it is to have an entity where it is necessary to create an internal channel, because the obligations of the legal entity apply to the internal channel. Because in an organization like that, there may be different kind of breaches. So this organization should have the legal powers to be able to respond appropriately to infringements, and it should also be able to implement procedures for operating such an internal channel. Referring to the Polish situation, an employer does not have to be a legal person. It does not have to have the civil law capacity to the so-called management notion of the employer. But if this is not a legal person, most often it is a legal person, but there's a big number of entities that do not have this legal personality, and they have, however, a series of rights that and towards their employees. Let's not forget that employees need to have this internal channel. And this obligation does not have to apply to others who also carry out the professional activity. However, it would be good for such an entity to be able to take legal responsibility, especially as regards compensation. So it needs to have this civil law capacity. But if it does not have, well, no harm is done, because then we assume that in the case of a legal entity which does not have its legal capacity in the broad meaning of the term within this employment relationship, so does not have the civil law capacity, then the responsibility is borne by these entities that have created such an entity, or who are, as we say, behind this entity. The fact that the legal entity is a complicated notion, it means that also a group of undertakings can be considered to be a legal entity. It was clearly expressed in the recital 55. And the last issue to finish, a whistleblower may make reports through different channels in a context related to his or her work. If a whistleblower in any way through its professional activity is connected with entity ABC, then he or she has the right to report it in the channel which is operated by each of these entities. I apologize. I think I spoke a little bit too long. So finishing right now, I thank you very much for your attention.
Professor Zbigniew Hein, thank you very much for your valuable contribution into our discussion. We are extremely grateful that in spite of your headache, you honored us with your presence and with your speech. Thank you for sharing your comments on the interpretation of the provisions of the directive, and thank you for presenting your concerns connected with the analyzed issue. It's true that the time frames have been exceeded, but the intervention was so valuable that I think it was worth to dedicate the time dedicated previously for the discussion, especially in a situation where there are no questions and asks. So we could spend this time listening to your valuable contribution. Thank you very much one more time. And now we are turning to the last panelist of the second session. And it's my great pleasure to welcome Mr. Adam Ożarowski, who is attorney at law at the legal department of the Ministry of Development, Labor and Technology, and a member of the ministry's team responsible for preparing the draft law implementing the European Union Whistleblower Protection Directive, and who will be speaking about the draft act on the protection of persons who report violations of the law. Mr. Adam Ożarowski, the floor is yours.
Thank you very much. Thank you, Madam Chairperson. And I would like to thank the organizers for inviting us and for giving us the possibility to share our experience related to the implementation of the EU Whistleblowing Directive. As it was announced, I'm a member of the interministerial team who was given the task to prepare the draft law, which in turn will be issued for public consultation. And this might be specifically interesting, I believe, for Polish participants and for Polish listeners to this conference about the stage of work. So very briefly, the work is in progress, and we aim to have the text out for public consultation in summer this year. We had hoped to be more advanced, a little bit more advanced in the project than. But nevertheless, it's quite a challenging task, and hopefully the text will be out this summer. Considering the topics which would be best suited for today's meeting, I was wondering that possibly it would be best to refer to the aspects that we found more and most difficult or complex that we have dealt with, not to refer to all the general framework of the implementing law. Obviously, the general framework would have to fit into would have to respond to the requirements of the directive. So involving the internal reporting channels, external reporting channels, the whole set of guarantees or support measures for the whistleblowers, for the reporting persons. But nevertheless, given the time limits, I would like to refer to maybe some of the aspects that we found a bit challenging during the drafting process. Of course, starting from the very beginning, we have to underline that in Poland, the protections for whistleblowers are limited. Of course, you might find different general legal provisions that in specific circumstances can be suitable to protect people that we understand to be whistleblowers. So you can find protection for witnesses in penal proceedings. Certainly, whistleblower who's an employee might turn for help to court, and obviously normally whistleblowing shouldn't be considered as a legitimate purpose, but for example for a reduction of salary or you know, the solving of the labor contract. But generally, it's very the provisions are only limited and not particularly directed at the protections of whistleblowers. So in Poland, this is going to be a new piece of legislation, and we are stepping into a completely new field in various areas. The first obstacle, or the first question that we encountered was the very broad material scope of the directive. Of course, we are moving within the limits of the EU legislation, and then the directive provides for a set of specific areas. This can be public procurement, this can be financial services, product safety, or public health. There are numerous. So the first issue was how to define the breach that is subject to reporting. And this is important because when you look at the text of the directive, you will find that basically the whistleblower, in order to receive protection, can be rightfully convinced that he's, first of all, that it's reasonably correct what he's reporting, but it's also that the breach is within the limits of the directive, but in turn within the limits of the implementing law. And one of the obstacles were actually that would be that to specify that the limits are the specific EU legal provisions, EU legal acts, would be extremely difficult for potential whistleblowers. So it's most likely that the text that we are proposing and that is going to be proposed would provide for a broader scope that the directive itself. The approach that it's going to be proposed is that it's not going to be only the breaches which are covered by the respective EU legal provisions, but also the respective aspects of Polish provisions, not to say not EU related. So financial services in general, public procurement in general. This is important both for the institutions that are going to be applied, but also for the legal certainty of the whistleblower. What is related to that is the reporting channels and also the entities which are going to handle the whistleblowing directive. This is again difficult in the context of the very broad material scope. There would be probably more channels and definitely more entities who will be the entities responsible to verify the reports. But in general, we are considering also some form of default measure, central institution or central reporting channel, or accepting the reports channel, accepting the reports. Speaking of the guarantees and the protection measures, one of the obstacles that you might find and that you might realize is that actually whenever you consider something which is a report, the first question would be, is it actually at the moment something which is unwelcome by the legal system, or something for which you could justly or rightly be punished, or you could be subject to any retaliation measures without the legislation that is being proposed at the moment? And practically speaking, the first reaction is no. If you look at the various provisions, a citizen may file a complaint to public body. A citizen, anyone, can report a crime, and this is not something that would normally be considered that should trigger any retaliatory measure. So in each case, you could consider whether actually anything which is covered by the report under the whistleblowing laws would be, so to say, necessary. What's the rationale to put this kind of provisions if it's practically at the moment a welcome and positive behavior by the citizens? Of course, we cannot. It's not necessary to convince the participants of this conference and of the drafters of the EU directive that it is necessary, basically for legal certainty, to specify all those protections. In labor law contexts, protect for any defamation claims, or protect for any disciplinary measures. Of course, for legal certainty, it's necessary. Nevertheless, in each of the cases, you need to keep in mind the various aspects that are related to the fact that actually, even at this moment, this is something which is legal and welcomed by the legal system. So, for example, what is the purpose for guaranteeing that a whistleblower will not be or cannot be subject to any disciplinary measures? Can you find a ground provide for disciplinary sanctions for the act of whistleblowing? No, that's not the purpose. Usually, you will not find the grounds in any legal provisions or internal codes, etc. But on the other hand, for example, you will find different provisions for the loyalty towards the employer, or different provisions on secrecy. So all those guarantees, so to say, would be specifically necessary in order to provide certainty whenever the law would have to be applied. Certainly, the drafting is it's a separate matter to provide for each and every guarantee on this context triggers the different drafting issues. So I'm not going to refer to that, but in each and every of this case, we need to think of this rationale for the guarantees. There's a number of procedural aspects, specifically given that the whistleblowing directive is so much cross-cutting. It touches on a number of issues, number of procedures, tasks of various public authorities, and one of the first questions that might apply is simply what kind of procedure is going to be applied for the verification of the reports. Of course, for that, the directive provides answers. Certainly, the relevant authorities would have to undertake the actions which are relevant for the breach. In certain cases, that might be the control procedure. Sometimes that might start prosecution in certain cases. So that's beyond the scope of the directive as such. The directive itself is very clear in the fact that, for example, it does not touch on the issues such as the penal procedures, for example. The directive does not change anything to that. On the procedural side, one of the questions that we were asked and that we ask ourselves here, and also that was one of the topics during the recent meeting of European Commission experts, who's a whistleblower? How do you become a whistleblower? And this is specifically relevant in the context of Article 20, Section 1, which touches on the possibility that certain countries may choose for some form of certification, so to say that the actions of a whistleblower entitle him to receive protection. So the basic question here is, should we opt for that? And our conclusions here in the process is that basically no. We should provide for requirements in order for the reporting person to be a whistleblower, or the reporting person within the meaning of the directive. But we are not considering the mechanism of a certification. And we believe this is specifically important in the context of the fact that there are more parties, so to say, or more stakeholders whenever a report is made. There is a person who might felt defamated, or in more typical case, there is also the employer. So we believe that it's more rightly in the Polish legal system would be to leave this possibility to assess this aspect for the adjudicating authority, specifically for the court. Obviously, not in every case a report as such would be related, would trigger the retaliation measures. In some cases, the report only would trigger the procedure which is envisaged in the directive. That is to say that the report will be recorded, the whistleblower will receive confirmation that the report was made, and he will be entitled to follow the process of the verification of the case. That is to say, he will receive the feedback. If he will not receive the feedback based on the general principles of the law and the directive, at a certain point he will be entitled to make the public disclosures. But nevertheless, all those cross-cutting issues were, from our perspective, each and every one of them was challenging, and possibly it might trigger also various comments in the process of public consultation and in the ministerial consultations that are going to take place. So that's very briefly of some of the issues that we have encountered in the drafting process. If there be any questions, I will be pleased to answer them. Of course, the advancement of the process, of the drafting process. And so for the moment, thank you very much for your attention. And of course, I wish you all other law drafters in other participating countries success in the drafting of your whistleblowing protection regulation. Thank you very much.
Mr. Adam Żarowski, thank you very much for your valuable contribution and for sharing your comments on draft law that is being currently discussed. I see 3 questions in the section of questions and asks. I think those questions shall be addressed to you, Mr. Adam Żarowski, so maybe there is a possibility to answer these questions. We have 3 questions in the question and answer section. As I said, there is a question about vacatio legis of the draft law, the law that is currently discussed, and we have the question concerning the way of regulation, of planned regulation of anonymous reporting. And we also have a question concerning an institution, an office dedicated to protection of whistleblowers. Can I return the floor to you to answer these questions? Thank you very much.
Thank you very much, and thank you for those questions. As for the first question, whether there's vacatio legis to be applied, most critical aspect of this is this specific provisions which provide for longer vacatio legis for medium enterprises, and certainly we envisaged that the legislation is going to use this possibility afforded by the directive. As for the vacatio legis per se, possibly it's a bit too early even for me to elaborate on that. We are doing our best to present the draft law in time required by the directive, and according to the advancement process and the provisions. At certain point, the general vacatio legis will be applied. But most, what I can confirm is this specific provisions for medium enterprises, this 2 extra years. Yes, it is going to be proposed. Second question refers to the anonymous reports. The anonymous reports per se are not as an obligatory measure under the directive. Nevertheless, it is possible, and the general approach it is going to be that both the internal reporting procedure and the external reporting procedure, but I would have to say that I use these phrases in plural, because internal reporting procedure means internal reporting procedure, obviously, in a given entity. Also, external reporting procedure is a procedure applied by certain entity. So there will be most likely a provisions which provides for the possibility to accept the anonymous reports. And whether there is a plan to establish a separate office for the protection of whistleblowers. No, there is no such plans to, at least this is not being discussed internally here. What is being discussed, how to divide the tasks for the implementation of the directives among the existing already authorities. Of course, replying to all those questions, this is a general remark. I'm sharing with you the discussions that we have and the progress on the draft law. Of course, this might be subject to changes in the course of the ministerial consultation and later public consultations. Thank you.
Thank you very much one more time also for addressing these 3 questions. I see no other questions being asked in the question and answer sections. There are also no questions in the chat. So I think it's time to close the second session. I would like to thank all the panelists, especially all the panelists, very much for the valuable, comprehensive contributions into the debate over the issue of improving workplace whistleblower protection in the Visehrad countries. It was my greatest pleasure and honor to moderate such an important session. I would like to express my gratitude to the organizers of the conference for allowing me to take part in it and for giving me the function of moderating the session. Thank you very much one more time. Madam Chairperson, Professor Skupień, I would like to return the floor to you to decide on further organization of the time frame of the conference. Thank you very much.
Dr. Smusz-Kulesza, many thanks for your moderation. Dr. Smusz-Kulesza is my colleague from the Department of European International and Collective Labor Law, also judge at the Regional Court in Lodz and expert in social rights of the Council of Europe. Thank you so much for your participation and the moderation for us today. And I would like to thank translators, interpreters for this gorgeous work in the first part of our meeting. So we owe you a longer break, and therefore, even though that we have a delay, I count on your understanding that this break will continue till 2:30 p.m. so that we could count on the same equally good level of interpretations after the home lunch. So please do not log out, stay with us, and looking forward for the afternoon part of the meeting. Thank you. 2:30, we are back. Stay with us.
Uczony, filozof, wielbiciel i propagator dobrej roboty. Profesor Tadeusz Kotarbiński. Od wielu lat uosobienie polskiej myśli humanistycznej. Uczony, filozof, wielbiciel i propagator dobrej roboty. Profesor Tadeusz Kotarbiński. Od wielu lat uosobienie polskiej myśli humanistycznej. Uczony, filozof, wielbiciel i propagator dobrej roboty. Profesor Tadeusz Kotarbiński. Od wielu lat uosobienie polskiej myśli humanistycznej.
My pleasure to open the afternoon session presided by Professor Peter Varga. I would like to particularly warmly welcome speakers of the first session and persons who are now joining our conference in the afternoon. I hope that all speakers are already with us. Dr. Edyta Bielak-Żoma, are you there? I hope that everything is okay with you, with your microphone. Maybe a small technical problem. Dr. Jarosław Stransky.
Hello, I'm here.
Hello, nice to see you. Mr. Patrick Stoniek.
Yes, hello.
Hello, Mrs. Zuzana Grochalowa. Still not there, but probably arriving soon. and Mrs. Julia Besch, with Wojtek Prerowski. So I'm handing over the microphone to my colleague, Professor Peter Varga from University of Trnava. Have a nice session.
Thank you very much. So hello everybody. Now I welcome the speakers and also the audience who can listen on the presentations. Well, we should start with Dr. Edita Bielak-Joma, or I'm not sure how to read the surname. So I'm not sure if she is here or not. Well,
Professor is there, but probably there is a short technical problem. Maybe we could switch the sequence of speakers.
Okay, so I would propose that Dr. Jarosław Stransky will start with his presentation, and after we can come back to the presentation of Dr. Bielak. Okay, is it okay for Dr. Stransky to start with the presentation now?
Of course, why not?
Okay. Perfect. So you have 15 minutes time. Dr. Stransky is a legal advisor of the Czech and Moravian Confederation of Trade Unions, and he will present the presentation on the position of the Czech trade unions on the protection of whistleblowers. So this is the issue that is discussed a lot. What should be the role of the trade unions in the protection of whistleblowers. So, Mr. Stransky, the floor is yours. Please present us your speech.
Thank you very much, Professor, for the floor. I hope that everything works. So, good afternoon, ladies and gentlemen. As the title of my presentation suggests, I will deal with the attitude of Czech trade unions towards the whistleblowers' protection. So thanks very much for the opportunity to present the union point of view in this mainly academic event. Let me preface this by saying that it's not my primary objective to assess the full context of the whistleblowers protection regulation. I'm going to address this issue mainly from the perspective of employees protection and obviously from the union perspective. Just for the starters, I included in my presentation references to these court cases involving the validity of dismissals. The employment contracts of these employees were terminated by their employers in clear connection with reporting certain wrongdoings. So these workers could be referred to as whistleblowers. You see that those cases happened a couple of years ago, but not that long ago. I don't have time to perform the analysis of the case law, and it's not even my intention. It's just to illustrate the fact that even here in the Czech Republic, there were cases and are cases and probably will be cases where employees are subject to some sort of retaliation from their employers as a result of reporting something that those employers didn't like for various reasons. After all, I have to point out the fact that in both these cases, the employees did not succeed in front of general courts. The general courts confirmed their dismissals as valid for different reasons. So the employees found support only at the Constitutional Court, which is remarkable, I would say. But as I said, I'm not going to go into further analysis of these cases. If you're interested in more information, there's a brief summary right in the slides, and there are also links to the wordings of both the decisions. The wordings are only available in Czech, but I think that's, if you're interested, then with a little help from some online translator, you will be able to understand what was at stake in these cases. You have already heard about the recent development of the transposition of the Whistleblower Protection Directive in the Czech Republic in the previous presentations, because Professor Moravec and Dr. Treslova from the Ministry of Justice were talking about that, so I'm not going to repeat it. I can just briefly summarize that about a year ago, roughly speaking, or a year and a half, the first version, the first draft of the new Whistleblower Protection Act was presented by the Czech government. The Czech Moravian Confederation did not support this first draft, along with a large part of the professional community for various reasons. So we recommended the proposal to be withdrawn and redrafted, which actually happened. So at the very moment, there is a new Whistleblower Protection Act, or proposal of the new Whistleblower Protection Act is being debated in Parliament, as you have also already heard. If the new act is approved quickly, the Czech Republic meets the transposition deadline, which ends in December this year, as you all know. If I look at this draft from the employees' protection point of view, I can point out that at its heart, in the core of the new regulation, stands a prohibition of retaliation. The act, or actually the proposal of the new act, states that it is prohibited to apply any form of retaliation to a whistleblower. So at first glance, this would seem to increase the level of employees' protection. So it seems that it deserves a big round of applause from the union. Well, not really. Closer look reveals that most of the actions prohibited by this new act are already prohibited in current legislation. Actually, almost all of them, all of these acts. So basically, in my point of view, this new legal act does not really bring something brand new into our legislation. For example, the new act is going to say that an employee cannot be legally dismissed for reporting some wrongdoing, for blowing the whistle, to say so. Wow, he cannot be dismissed. Okay. The Czech labor law contains exhaustive lists of legal grounds for termination of employment at the moment. So even at present, an employee cannot be legally dismissed because he or she has reported some irregularities. Nothing really new. The same could be said about remuneration. The new statutory regulation is to provide that no one's pay may be reduced as a result of the notification of something. Wow, again. But again, current Czech labor law contains such instruments as equal treatment, equal remuneration. There's a binding list of criteria for remuneration, for determining the amount of pay. There's quite strict regulation saying that the wage must be provided only and just with regards to work, to complexity, responsibility of the work, with regards to working conditions, work efficiency, results of work, and full stop, nothing more. So if the employer complies with the existing regulation, he cannot, even at present, reduce employees' pay because he or she reported some illegal or immoral activity or something like that. So my impression is that this new regulation will not bring anything really exciting in terms of employees or whistleblowers protection. On the other hand, I have to admit, I already said that there were and there are cases of various disadvantages or retaliation from employer. These cases do occur. So if the new legislation helps to identify some of the employer's actions as unlawful, well, it may have some value. It may be useful as a kind of, I would say, supportive instrument. In my view, the crucial point will not be the exact wording of the legislation, but rather the way it is applied, which is not really a surprising conclusion, is it? But if I take a look at the internal reporting regulation, one of the new mechanisms, so the obligation for employers to set up an internal reporting channel, well, that might be interesting instrument. But obviously it will depend on the companies, on the employers themselves. How consistently, how seriously will they complete their new task? That will have major effects on how useful will this measure prove to be. As regards external reporting, as you have already heard from Dr. Treslova, the designated competent authority in the Czech Republic will be the Ministry of Justice. I have to say that this fact raises some questions. Probably there's going to be a new department on the ministry. New department is going to be established to deal with this agenda. How effective, how competent will it be? In my presentation, I took the plunge to outline some points that I figured as basic benchmarks for what I would consider as features of effective functioning. In particular, I have underlined autonomy. I mean, the possibility to freely and seriously deal with the reported cases with no political or financial or whatever interference. I consider these aspects to be crucial, and frankly, now I will take the advantage of the academic freedom of speech and I will say what I wanted to say. I have considerable doubts about the level of autonomy or independency that will be afforded to the officials within an institution such as a Ministry of Justice. Each ministry is always directed by a minister. Minister is always or usually part of a member of a political party. Political party is connected with some sort of financial circles, lobbyists. So how effective will the functioning be? We will see. In conclusion, I'd like to summarize that from the union or from the workers' representative point of view, I really don't think, I cannot say that this new act, which is going to be adopted, will somehow significantly increase workers' protection. Hopefully it will not reduce it. The whistleblower protection contained in the new act, which is going to be adopted in order to provide the implementation of the new directive, will probably play more or less a supportive role in terms of identification, applying and enforcing the prohibition of retaliation. I really don't think that the prohibition of retaliation itself will bring effects of some sort of magic formula, that just as a result of adopting the new acts, employers will start supporting their whistleblowers, congratulating them for their courage and decorating their offices with flowers or something like that. That's not going to happen. We all know that. It's not going to happen. I think that rather soft factors will play a decisive role. Soft factors which cannot be determined or directly influenced by legislation. First of all, the level of, I would say, enthusiasm of the new staff of the Ministry of Justice Department. How will they deal with their new agenda? Time will show. The other soft factor relates to the approach of the companies. How seriously will the employers deal with the new obligation to set up an internal reporting channels? I don't want to be too skeptical, but I'm afraid that many employers, especially medium-sized or small enterprises, small companies, will approach this obligation in a very formal way, I would say. However, I'd like to express certain expectations, especially from the larger companies, big companies. I think it might work there. And even for that reason, I'm quite curious about one of the upcoming presentations, one of the following presentations. If I understood that correctly, it should be given by a representative of a big Czech employer. So I'm really looking forward to that. Thanks for your attention. That would be all from me.
Okay, thank you very much. Dr. Stransky was really exact. You had 15 minutes left, and now we should continue with another presentation. And I'm not sure if Dr. Bielak has still some technical problems because I can see you, but maybe we can hear you as well.
Yes, I'm sorry for the confusion, okay. But I am ready.
Okay, perfect. So you are from the host university from Łódź, so the floor is yours now, and you can have your presentation. So you can start maybe sharing your screen, and so that we can see your presentation. Perfect.
Okay, thank you.
Okay. Thank you.
Thank you. Thank you. I will try to say the most important points to me. In Poland, there is currently no comprehensive regulation of whistleblower protection in Poland. And there are also no provisions relating to the protection of whistleblowers' personal data. It fails to provide comprehensive regulations regarding the protection of whistleblowers, to define the concept of whistleblower or irregularity, to define detailed procedure of mechanisms, be assumed that whistleblowers in Poland are subject only the provisions of the GDPR in terms of the protection of their personal data. In my opinion, whistleblowing is one of the most effective tools in labor law, whistleblowing tools in labor law. First, it prevents irregularities. It allows to respond to threats before irregularities occur, provides an opportunity to correct mistakes before irregularities escalate in scale, before losses to the institution of the public occur. It provides ongoing control over employees and working conditions and relation between employees and contractors. It allows you shape the culture of the organization and modify undesirable states or behavior. Employees are aware of their responsibility in reporting violations. The reports have to be truthful, serious, etc. So it creates, I think it creates the need for a fair assessment of the situation before reporting it. Whistleblowing increases employees' sense that their assessment of the workplace situation can be important, valuable, and relevant to improving the situation, the workplace situation. It interferes less with employee privacy than employee screening. Control always involves supervision and monitoring of the employee. Whistleblowing involves trusting that employers they act in the public interest. I think whistleblowing serves to protect the public interest and the interest of the parties to the employment relationship. The internal channel should provide effective whistleblower protection. We know the channel, in my opinion, the channel have to be special. It means it have to dedicated to reporting irregularities only. It should be independent. This means operated by authorized person. The channel should be autonomous. It's not connected with other channels of communication between employees and between employees and employer. Another element that provides protection is the development and implementation of procedures. They cannot be universal, the same to all employers. They should take into account the specifics of the employer, its size, nature of its business or operations, area of activity, structure, organizational, the culture, practices, and maybe habits at the workplace. This requires the employer to make a responsible decision which person or maybe team or department, internal or external, will be entrusted with the channel operation, who will provide the best guarantee of confidentiality and processing of personal data in accordance with the law and standards. The design of internal channels of communications may depend on of different elements. I think the size of the employer, its organizational structure, industry of sector of activity, level of risk of potential fraud. An employer with a more complex structure, public authority, public body, public entity, or a critical infrastructure entity, employing a large number of employees, cooperating with a large number of contractors, operating in market segments exposed to infringement, will have to establish a methodology in which the whistleblower should report the irregularity, or maybe branch or headquarters, and decide on the course of action. The workplace situation is important when assessing the internal channel. It's important whether there is a code of good practice or a code of conduct in the workplace, because employees know what behaviors and actions, for example, are undesirable, and it is important how to report them and to whom. The whistleblowing, the current whistleblowing practice is also important because if the employer has used whistleblowing mechanism in the past and they have been effective, that current solution for the reporting channel may be based on this, I think. I have already mentioned that signaling is of particular importance in public administration, because for public servants, work is a service to society and to the state. They must be loyal to the office they work for and state. Loyalty improves legal transactions and increases trust in the state. As civil servants have to be very responsible and objective in assessing that before deciding to report. Although criticism of the employer is admissible, employees are bound by the principle of loyalty, which manifests itself in acting in accordance with the law, responsive, of course, representing the interest of the state, caring for the good image of the body of the office. So, in addition, the employee responsibility, public servants are also subject to disciplinary and sometimes political liability, although they should be apolitical in their actions. But in many public bodies, the employer is the politician's choice. As a result, the whistleblower may be exposed to retaliation not only from his employer, but also sometimes from politicians. It's very important build a good whistleblower system. A arcane system as it guarantees the confidentiality of the whistleblower and strengthens his sense of security against relation. The role of signaling has been emphasized by the Supreme Court in Poland. In one of its judgments, the court indicated that public servants has not only the right and sometimes even the obligation to report violations. The internal channel is created by the employer, it means by the office or bodies or body or entity. The external channel is used to report violations to external bodies, for example, higher authority, in Poland, the National Labor Inspectorate, the Supreme Audit Office. However, in complex organizational structures, the matter is more complicated. Sometimes it is difficult to clearly indicate whether a higher authority is the one to be treated as an internal or external channel. Taking into account the purpose of signaling, it seems to me that it will depend on, for example, the legal basic of the operation, the status of the unit, and the level of functional, financial, and organizational independence. The next important thing is the selection of employees to handle violations. They should be experts in the field of law, of course, the protection of personal data. They should have detailed prerogatives, right of employer to access full documentation, to communicate with all persons, and from the view of, from the point of view of personal data protection, extremely important. It's extremely important that this person have specific authorizations to process personal data in order to settle the matter. The problem I mentioned can be seen on the example of National Labor Inspectorate. It is a complex public authority. A National Labor Inspectorate it is the employer and data controller for all inspectors controlling employees employed by the inspection in all its branches in Poland. District labor inspectorates are employers and data controllers for administrative employees employed in individual district inspectorates. There is one IT system in the inspectorate. It is introduced at the headquarters level. So in Poland, we have 16 employers in one functionally connected organizational structure, National Labor Inspectorate. In this context, question arises. For example, should there be one or several channels? Should there be one team of specialists or one for each employer? Should the teams operate at the level of headquarters or at level of district inspectorates? Is the notification to the National Labor Inspectorate an internal or external channel? Is the notification? What are the rules of conduct? The same or different for each employer? Is data retention determined by the head office or maybe local employers? These questions are just the fit of view of the purpose of the whistleblowing. The purpose of the channels is to prevent abuse, care for the interests of the employer, serves the society and the state, protection of the whistleblower, of course. If so, it seems to me that a solution should be introduced that will be most effective for the body as a whole, for entity as a whole, and will provide the best guarantee for the protection of the whistleblower, including the protection of his data and confidentiality of identity. Finally, I think the Polish legislator should create a uniform model of whistleblowing as an institution. It seems comprehensive whistleblower protection should be regulated in a separate legal act. And it is very important for me, the legislator should oblige the employer to provide reliable and transparent information to whistleblowers about their rights. Thank you very much. Thank you for your attention. Thank you.
Well, thank you very much for your interesting presentation. Focused on public administration and the specific of this area of law with respect to whistleblowing. Well, and now let me welcome the next presentation, Mr. Stoniek, who is an expert in labor law and who works as an academic at Charles University and as well for the, I think, biggest Czech company, I think, if I am right, for Škoda Auto. So the floor is yours now, and you can present us the self-investigation and whistleblowing protection. So the floor is yours.
Thank you, Mr. Varga. Can you hear me? Can you confirm it?
Yes.
Thank you. And can you also see my screen?
We can.
Great. Thank you again. So, hello. It's my pleasure to say some, let's say, I hope at least interesting points or things from our company, which how whistleblower protection could look like in practice by one of the Czech biggest employers. Well, it's actually the biggest one, I think, right now. The whistleblower protection exists in Škoda Auto for several years, let's say for the last 4 or 5 years, and we call it a system dedicated to the solution of notifications of various group of persons, especially employees. This topic is centrally managed by the Volkswagen Group, but its specific form, of course, reflects the conditions of the Czech law. The reason why this system is managed by the Volkswagen Group is that the group wants to have not the same, but at least one similar system in all companies all over the world. So this is why we also have a system which is quite similar to the German one. You can say that the whistleblower protection in Škoda Auto, whistleblower protection resulting from the legislation of the European Union and also from the subsequent legal regulations of the Czech Republic. And this is why it hopefully will not mean revolutionary changes for us, for Škoda Auto. However, we have to make some small adjustments to our existing system. In my following speech, I'm not going to be so, well, let's say, theoretical as my colleagues, and rather practical. And I'm going to present the system existing by Škoda Auto. We can say that the possibility to draw attention to violations of legal regulations or internal regulations of the Škoda is not limited only to our employees, but also to any other persons. It could be customers, it could be our business partners. It doesn't matter who the person, who the whistleblower is. But naturally, however, the most frequent whistleblowers are our employees. They can choose in various ways in which they want to submit their notification or their reports. They can do it in person, they can do it by telephone or in writing. Regardless of the method of the notification of the report, the whistleblower may be guaranteed his anonymity if or she so wishes. It's also possible to submit an anonymous notification as it happens. We also have some other ways to protect our whistleblowers, which means that they don't have to submit only in the Škoda Auto their notifications, but also through another channels managed by the Volkswagen Group. Such channels also include the so-called ombudsman. These persons are lawyers, and this is, let's say, the German model of the protection of the whistleblowers. Upon a reception of a notification, some, let's say, procedural steps have to be taken, and after that, the notification or the report will be investigated. There are a lot of departments in the Škoda Auto that could investigate the notifications, but we also have some special bodies in the Volkswagen Group. They could also do it. And sometimes it happens that mandate to inquiry is given to external lawyers. Yeah, it happens from time to time if there is, let's say, a conflict of interests with another of our employees. We work with the need to know principle, which means that only the necessary circle of persons is involved in the investigation. I would say this principle is new from the, let's say, criminal law, which means that's nothing new, I think. This also regards the materials related to the investigation. So also the access to the materials is limited only to the necessary circle of persons. They have their own rights, and this is how it works. We also try to follow the standard procedural principles existing in criminal law, which means the principle of a fair trial, the principle of the presumption of innocence, or the right to be heard, of course. The protections provided to whistleblowers not only during the investigation, but also after it. And this is very important. However, it's not provided to those whistleblowers who knowingly submitted false notifications. We also had some of these cases, and I'm gonna mention at the end of my presentation one of them. The investigation itself and the subsequent steps must, of course, take place within the set deadlines. This is what the European directive and also the proposal of our Czech law prescribes. In the area of HR, where I work, we have a, let's say, special kind of the whistleblower protection, and this was explicitly incorporated in this area last year. I was responsible for it, but also before this step, employees in the Czech Republic enjoyed sufficient protection, as Mr. Stransky already said. It resulted from the general regulation of the whistleblower protection in the Czech Republic, and also from the Czech Labor Code, which prohibits employers from punishing or disadvantaging employees in any way when they are legally claiming their rights. I can show you some sections from our civil code and the Czech Labor Code. And when you read it, I would say you would share my and Mr. Stransky's opinion that there is enough protection for our whistleblowers who are employees, but not only for them. This is only just as a brief remark. I go back to the presentation. As I said, we inspired, or I inspired when I was creating or establishing, implementing the whistleblower system in the area of HR in the European Union's legislation, also in the Czech legislation, in the Czech proposals, and the proposal draft of the whistleblower protection. Therefore, it's common practice in the area of HR in Czech that after the notification has been submitted, the whistleblower is notified of his receipt, that there are relatively short deadlines for investigation, if it's possible, 30 days, and that the whistleblower is informed about the result of the investigation when it's closed. I can also mention that the notification investigated once constitutes an obstacle to res judicata, which means when one notification, one case was investigated and decided, then that in the future the same case cannot be investigated again. In order to avoid the need for more partial processes in our area, dealing mainly with various problems of our employees, we created one robust universal system. The system thus contains the same rule for the investigation of the employees' notifications and everyday personal topics. I can, for example, mention presence employees at work, non-wearing of mouth and nose protection, generally face masks, etc. Or maybe the smoking at work. One universal system was also created due to the fact that in practice it's not possible to establish a clear dividing line between common personal problems of our employees and other notifications. This is why we made one universal system. But however, it's true that the last mentioned step meant a significant increase in administration, but I would say it was worth it. There have also been a standardization of our existing procedures and more consistent application of the principle of equal treatment, which I can clearly assess as positive. Maybe I should also mention that to act against own employer needs some courage for the employee, because it's not that easy to come, let's say, to the superior and say, there's something wrong and I want you to do something with it. And if not, I'm going to go to your superior, and so on and so on. This is why we have to protect the whistleblowers. But the whistleblower protection should not only be there for the whistleblowers, but also for other persons who are or who have to deal with the investigation of the notifications, which means we have to also protect the witnesses. We also have to protect other people who are participating in the investigation. I can show you some concrete provisions of our internal regulation with how this internal regulation could look like. This provision 1.3 is for our whistleblowers, and as I said, we don't protect all the people who who submit knowingly false notification. But generally, we of course protect our whistleblowers, and some kind of penalization or disadvantaging of them can particularly consist in these, let's say, 3 examples. But as I also said, this is only an example, and we want to protect, and we protect our employees in all ways before any way of punishing or disadvantaging. These other 2 provisions, they regard the protection for other people who are taking part in investigation. We have one, let's say, a committee, it's a personal committee, and these people decide about the notifications. We also have its secretary of this committee, and also some investigation teams and witnesses. For these people, there is also a quite high level of protection, I would say. And as I said, it could also happen that there is a conflict of interest between the people who normally should investigate the case, the notification, and if there is such a case, they of course cannot take part on this investigation, and we have another rules for this. Okay. Back again. Okay. There are also some, let's say, shadow sides of the whistleblower protection, because Škoda Auto is one of the biggest employers in the Czech Republic. We have 35,000 employees, and we also have some, well, let's say, notorious complainants who feel that someone is constantly hurting them, and they want to abuse or misuse this whistleblower protection. Here, the whistleblowers could abuse the system in order to deal with private problems through the common employer, or they want to become harder dismissible or undismissible. 1 month ago or 6 weeks ago, we had such a case. We received 3 notifications. It's the case 2 on this list, on this slide, regarding behavior of one single employee, and these notifications or the suspicions regarded particularly stealing, alcohol consumption, and forgery of working hours. The case was investigated, and it was assessed that all these 3 notifications were knowingly false and that they came from one person. This person used to have a relationship with the suspected employee who broke up with her, and that was her revenge. Means that she wanted to, say, ruin his career or to harm him, man. But also we have good cases when how the whistleblower protection could look like. We received an anonymous notification which was assessed as true, and the content was that some employees stole in their workplace car parts, and it was true, and it helped us from bigger damage. When I should summarize my speech, the whistleblower protection is an established system in the Škoda Auto, which allows employees in particular to draw attention to violations of legal regulations or our internal regulations without having to worry about any retaliation. But although there has been an increase in administration with the implementation of this system, and there are some sub-aspects of the whistleblower protection, as well as other institutes, and as well as in all, let's say, legal regulations, which could be or may be abused. But I would say that this does not mean that the implementation of the system was a mistake. Thank you for your attention.
Okay, thank you very much for your presentation. And there are 2 questions that are directed to you. So I will read the question. So does Škoda have a dedicated IT channel or a platform which allows a chat with an anonymous whistleblower? So it's a concrete question. So do you have also some IT channels or IT platforms on anonymous basis in Škoda?
We provide a special email which could be used for this, and there are also some other ways which are, well, let's say, governed or managed by the Volkswagen Group.
Okay, and the question seems to ask if there is an anonymous possibility to chat. Yes. So it is.
Yes, there is.
Okay. And also the second question, are you a compliance officer in Škoda who supervises the whistleblowing system in your organization?
I'm not the compliance officer. That's or the whistleblower system is governed from another department. I do not work in this department, and and who supervise the whistleblowing system in your organization. We have a special department for it. It's called Governance Risk and Department, and the head of this department is supervising our system.
Okay, thank you very much.
Welcome
for answering also these questions. And now we will also move from the Czech Republic to the Slovak Republic. So from one country to another. We will also move in our presentations from lawyers to social aspects of whistleblowing. So and also from company or private companies to non-governmental organization. Well, I welcome Zuzana Grochalová from the Slovak Republic, from Transparency International Slovakia, who will present us the data from Slovak experience of whistleblowing and the protection that is granted to whistleblowers and the paid remuneration. So the floor is yours.
Thank you. I hope everybody can hear me and the presentation is already visible. Could you confirm, please?
Yes, I can. We can see your presentation. Maybe you can speak more loudly.
Okay, so thank you once again to everyone, and thank you for inviting me. I've been present partially last year, and then I missed my chance to present. So thank you for opportunity to come again and meet you online. I will present today, as it was told, view of Slovakia as a country that already has a legal protection law in force for several years, and therefore we do have some data. As it was already repeated today several times, to have a law, it's just the first step to carry out and carry on the protection requires more. It's a long journey, and since the law in Slovakia is in force from 2015, I will share today with you some lessons we learned. I am in Transparency International Slovakia, chapter of international movement that is fighting corruption. Whistleblowing is our agenda since 2002. And I'm working as a project coordinator / fundraising junior. So I also see these background issues when you are trying to communicate lobbying or advocating for whistleblowing agenda itself or cases in particular. So that's about my background and my organization. And we can proceed to more specific details. So even although we are part of the international movement, our chapter comparing to others is quite small. We are just a team of 8 people, and the topic of whistleblowing is carried out by 2 employees currently. One is me, and I do it as a part-time. And we have also a lawyer in the organization that is helping whistleblowers if they need a consulting or advice, but we do not represent them. It's over our capacities. I will represent you today briefly our initiative Backing the Bold Ones, which is helping whistleblowers who are facing retaliation. I will also present you some trainings of administrative and self-government bodies outcomes, few of details and good examples, which we have experience with. Public counseling is done by my colleague, a lawyer. We did participate when the law was drafted and also when there was an amendment of the law drafted in Slovakia as well. Our chapter was active when directives was shaped. We were writing objections and notifying in consideration what is working and what is not working in our country, as we already did have a legal frame. And we can maybe later have a discussion about how outcomes are drafted and designed for our social media and communication channels. So as previous speakers already mentioned, just briefly, there is already law in Slovakia, which is effective since 2015, so it's already 6 years. And there is also the amendment, which brought a few new, let's say, few new measurements, including new already mentioned office. And what was mentioned by previous speaker from Slovakia, the important thing when speaking about whistleblowing, it's especially from the title of our organization and my job, it's to work with data. Here you can see the development of Slovak population. If they know there is any legal guarantee, any legal protection for those who would raise a voice. From the May 2016, and the fresh data are from the May this year. So 5 years. We started when the law was in the force for more than a year. And as you can see, currently, half of the people, they don't know, half of the population of Slovakia doesn't know there is any legal protection in the country, although the law itself, it's already here several years. So the best year was 2007. Also in another, we were measuring with the public opinion polls, also other questions. And that was a year when we had a massive, robust, big case when a government clerk stood out and reported wrongdoing, and also inspired other people to speak up. And as well, she did a lot when it came to a recognition of the law and that there are legal guarantees to protect those who speak up. It was a case of Zuzana Hlavková, you might heard about, and the European Union, we were like presiding. I will proceed. We are repeating this question every year to follow the trends and try to read what are the current trends in our society in Slovakia. This slide I will speak just about briefly because it was already mentioned. It's what are the differences between European directive and Slovak law protecting whistleblowers. Our lawyer did analyze even before amendment, and that time the difference is, let's say, in a mathematical way, just 5%. In some details, directive is wider. In some details, our law is wider. More or less, it's the same. That's also why transposition is not such a big topic in Slovak media and in Slovak stakeholders' discussions and debates. Previously, Mrs. Director of new whistleblowing office was mentioning the number of granted protections. That time it was by labor inspectorates in the years 2015 and 16. We do have data from the last year, which was 13 granted protections, and the year before the same number, 13. So as you can see, there is no growth or increase in the number of those who received granted protection by labor inspectorates. And we hope this will also change with the new office, because one of the reasons we identified after 1 year since the law was in the force, we tried so-called mystery shopping, and we contacted the labor inspectorates on the county level, and they were not carrying out their duties according to the law. We identified later on the reasons. One of them was that all the labor inspectorates in Slovakia got a new agenda to the whistleblowing. They didn't get no extra funding for the personnel, neither training. So they just got new tasks, but no support from the government. The quote, which is in Slovak, was claimed by a new government, which is now in parliament since last year, February, when they, a little bit later, when they won the elections. And this was their program statement when they were guaranteeing that the new office will be established, as the delay was already quite long at that time. So in April last year, they were stating that this is a priority for them. Although they claimed we had to wait a few more months, and finally it happened in the end of January this year that Mrs. Dlugošová has been elected by the parliament. Another data, this was the last year public opinion poll in which we were asking if a person would be willing to report a corruption at the working place. This is also one of the trends we are following for several years to measure trends or changes. As you can see, more than half of Slovaks wouldn't report any wrongdoing at the workplace. 7% doesn't know, and just 36% would report. As I spoke before, the highest level of willingness to report such wrongdoing has been measured in the year 2007 after the case of speaking up Zuzana Hlavková about wrongdoing at Ministry of Foreign Affairs. Since that time, the willingness to report, it's decreasing or not changing at all, but we don't see any positive changes since that time. I mentioned also Backing the Bold Ones initiative, which is it's an initiative designed by mentioned Zuzana Hlavková. After her case was revealed, she was also part of our team for a year, and she helped and worked a lot with whistleblowers, and especially those who are from the public sector. And this initiative was designed and introduced and launched by her personally. And this initiative it's designed by 700 companies which are united in various unions, Altogether, they were employing more than 200,000 employees. And the idea was that the public sector would commit a zero tolerance to corruption and malpractice or wrongdoing, and would guarantee the job interview, workplace coaching or training for the profession for those who would face retaliation or job loss in the public sector. We already helped several clients via this initiative, but the main impact of this initiative is in prevention. So no one can threaten anymore any whistleblower in Slovak public administration sector, as a person has this backup system that they can find a job via this network of employers from the private sector. This is a quote of one of the businessmen who is from Slovak Compliance Circle representative, who is also involved in this initiative of backing the bold ones. We were collecting for social media outcomes their quotes to support launching and then getting out the first year of the initiative itself, which helped a lot because those are respected businessmen and businesswomen known for their high ethical standards. When speaking about the public administration bodies and data, every year for the last 3 years, we are requesting 28 key public administration bodies by guarantee law access to information, and we are asking a set of questions which are about whistleblowing reports inside the organization, as those are not part of their annual reports. As you can see, last year, we were asking this in January and obtaining data for the last year, there was a massive, robust increase in the number of reports comparing to previous years. We can maybe later on speak about the reasons why. One can be that the government changed and the new government was claiming before elections like corruption fight, also like ministry representatives have changed. But in the other hand, you can also see there was as well a massive, robust increase of irrelevant reports. This is the dark blue number, which increased significantly as well as a number of reports. This is another data set from, before I noticed one of the previous speakers from Hungary was as well speaking about queries and questionnaires delivered and distributed to various public and governmental bodies. So we do something similar, but in the smaller scale. And one of the questions we were asking and are asking yearly is if there is a training for employers in the office, public office, about the whistleblowing, as it should be at least trained the so-called and already mentioned responsible person. Of course, pandemic changed this as well, education. On the other hand, we saw that it's possible also in online and distant home office conditions to train people and educate them. But current data says nothing changed comparing to year 2019, and the number of those who were trained, which was lighter blue color, didn't grow significantly last year. So when speaking like some close up with this 28 public administration bodies number of reports in total were 51, which is 10 times more than previous years. Number of offices with at least one report or more have been obtained, it's 8. And what's important to mention as well is that every 8th report has been filed to police or prosecutors. There is investigation going on or already closed. As I mentioned, there is this big increase of irrelevant reports, which was every 4th. So it has to be taken in consideration that this also consumes time and personal capacities of personnel who are designed to be, by the law, responsible persons for the whistleblowing reports. As I was mentioning before, there is this, by the law, defined duty. I'm not a lawyer, so I'm not sure if I'm using correct wording, but I guess we will be in the context. The responsible person in the organization should be educated up to date whistleblowing legislation in Slovakia. And this was a number of figures, how many of them in those 28 administration bodies has been in the previous year trained about the whistleblowing agenda. So from it's those numbers are actually positive, and there was again not so big change in the last year, and the trend seems positive to us. As a light blue is yes, there was a responsible person educated and trained, and the dark blue it's the person has not been. So this is Zuzana Hlavková herself delivering a speech about her case and whistleblowing and ethical standards. What is important to mention, although in the public administration body we see improvement, the black and bad news are from public, like general prosecutors or prosecutor offices. In the December last year, we have been asking again by request for information emails guaranteed by the law about the access to information, about the number of reports inside the county and district prosecutor offices. There was a 0. Since the law is in the force in these prosecutor offices themselves, there has not been any report at all, which is quite terrifying, thinking about the fact that the prosecutor himself or herself is the person that should grant protection to whistleblower. We were going since government change also through some changes in prosecutor and judiciary system in Slovakia. In autumn, there has been several rounds of public hearings of candidates who were candidating to become general prosecutor and also special prosecutor. And as these public hearings were quite tough, several times the candidates were asked why they didn't report any malpractice or wrongdoing when facing it at workplace. But although there was a general knowledge that something fishy is going on, they were speaking excuses like they didn't have a direct evidences or they didn't have a chance. And this illustrates, according to our opinion, perfectly like when the culture in the organization is about the silencing, you will have a 0 reports, neither the irrelevant ones. So we hope after there were personal changes, this will change as well, as the prosecutors are part of the whistleblowing system in Slovakia. Maybe good example to mention, in Serbia, they have Pištalka organization, and they're training judges how to handle whistleblowing cases. So this should be maybe taken as consideration and lesson learned how to improve also the system of prosecutor and judges who are handling whistleblowing cases. But a success story, I have mentioned Zuzana Hlavková, who was a former employee of Ministry of Foreign Affairs and pointed out wrongdoing at public procurement. She didn't receive the protection. I can tell maybe a bit later about the details, because there were debates if she used the proper channel or not and the way she reported it. She was the one, as I mentioned, the idea maker of initiative Backing the Bold Ones and lecturer for Transparency International School of Integrity International Summer School, which is open for anyone who would like to learn more about the anti-corruption fight, including whistleblowing mechanism, trends, and opportunities in the both years 2017 and 19. Another good news, when we are speaking here about the culture of reporting and willingness and how whistleblowers are perceived in the post-communistic countries, this goes in the hand with a trust of citizens and population that if they report something, it will be investigated and punished in the best scenario. So as you can see in Slovakia, this is the shift. There is a huge increase in prosecution of corruption crimes, as well as huge increase of charges of corruption crimes. So those are the data during the last year since the new government is in the parliament. So we hope that this will also help to increase the trust in the judges, prosecutors, and police, as those are the one working closely as well as with the new whistleblowing office. And those are the one whistleblowers themselves will meet personally during the whole process when being granted the protection, when being in the processes at the courts. One more good news, even we have since the beginning in the law that there is a provision, award or a remuneration for whistleblowers to pay them back their costs. And this is a usually hard question to discuss about how to calculate it. There was the first and only historical whistleblower rewarded in Slovakia. Here I put the exceptions from our law, how is it qualified, and how that it's a maximum 50 to the value of minimum wage. So it's not a fixed amount, it's changing as a minimum wage is changing in Slovakia. So who was the first whistleblower who was awarded in Slovakia, and how much was it? So it was Mr. Rastislav Šalink. Sorry, there is a typo. Although the case itself was several years going on, he received last summer 3,150 euros, which was paid by Ministry of Justice. Ministry of Justice, together with labor inspectorates, are substituting the roles of the whistleblowing office until it's established and run itself. And Ministry of Justice was responsible for the rewarding agenda for whistleblowers, and that was the ministry that paid this reward to the whistleblower. A bit more about the background of the whistleblower. It's a person working in the healthcare system, out of capital, actually in the east part of Slovakia, who reported wrongdoing. Its office, which is dealing with preventing and occupational medicine at the regional level. And he exposed fraudulent measurements of the health officers. They were faking documents, and they were asking for bribes, and there were several breaches of the law. The result of his action was that the person that was proven at the court that did wrongdoing didn't went to prison, but it's with same condition. He lost his, he is not working there anymore, and the whistleblower himself was rewarded by this amount by the ministry. He was, even with his reporting, it was not so easy and not so smooth, but we are happy that finally there is one person that can be presented as a good example for those who are considering to speak up. So thank you, and thank you for your attention, and if any question, I'm happy to answer.
Thank you very much for your presentation and for providing the very useful statistical data and your practical experience with cases you mentioned in your presentation. Well, we will now continue, and we will continue to the last presentation of today. This presentation will be shared by Julia Bez and Wojciech Prerowski. So I think it's the Polish and Czech presentation, as I understand from the program. Julia Bez has a practical experience in anti-corruption in private companies. She also is doing her PhD in Warsaw. And Wojciech Prerowski from the Czech Republic works as a lawyer for Veolia. So the floor is yours, and I think the presentation will be presented by Mrs. Bez. So you can start with presenting.
Please confirm that the slides are there.
Yeah, we can see your slides, and we can also hear you, and we can also see, and maybe I hope also to hear your colleague Wojciech Prerowski. So
hopefully, yes.
Yes.
Hello, everybody.
I confirm.
Wojciech is present. Okay. Thanks God, although the delay. So good afternoon, everyone. I was already presented by Peter, but yeah, I represent the DZP legal office in Poland.
And I'm very glad to be able to be here and participate in such a prominent conference among all the great panelists here. Today I will speak about the legal design methodology as the new approach towards the establishment of rules for the more effective implementation of whistleblowing systems in different organizations, but mostly focusing on the private sector. And I'm especially happy that Wojtek Brodowski agreed to join me during this session because he is an experienced compliance officer for Central Eastern Europe of his company Veolia. And this is one of the biggest entities operating in the energy and water sector. And I hope that what I will introduce from this theoretical and statistical perspective will be commented by Wojtek by his practical experience. So first, I would like to start my presentation with a short reminder. It was already mentioned a little bit, but now I want to set some data that whistleblowing systems that existed on the market before it was obligatory under numerous regulations of law usually were and still are part and the pillar of complex compliance management systems. And the different studies show that one of the functions of compliance systems is to prevent the organization from financial losses that these entities might obviously suffer as a result of irregularities, abuses of law, and internal frauds. I personally believe that this role of compliance system is one of the most important ones that determine the decision of its implementation within the companies from the private sector. But the whistleblowing system is one of the tools in such a complex compliance system and one of the most basic ones according to many benchmarks that exist on the market, such as, for example, the ISO norms. According to ACFE report to the nations, the companies that introduced at least basic compliance solutions, including whistleblowing, recorded more than twice lower losses in the event of the violation of rules, and that proves that having a whistleblowing system simply pays off. But we must also remember that this is not only the direct sum of money that might be subject of such a loss, because when the wrongdoing takes place, what automatically follows is an image loss. And especially now in the world of extremely fast exchange of information in the media, after the irregularity happens in the organization, we can quickly find the newspapers describing it as the scandal on their front pages, and such a situation becomes a reputational risk for the company, which might also affect its global market value, meaning also affect the financial situation. And according to managers of the companies from all over the world, because the study was international, 63% of the company's value is based on its reputation. And the similar study of economists additionally showed that the value of shares of the companies listed on the stocks depends on their reputation in more than 35%. And that explains why after every media scandal discussed widely in the papers that happened in the organization, very quickly we note a dramatic decrease in its stock value. You can see on the slide here the record of the statistics of stock value of one of the pharmaceutical companies. And at the same time, we should remember that all the risks and fraud and abuses of law rise annually, but their most visible increase was being noted in the first month of COVID-19 pandemic, and the professional predictions expect this risk to still increase and gradually over the next months. So considering all these statistics and considering that at the same time about 40% of irregularities are being discovered thanks to the whistleblowers' tips, we should find a reporting system one of the most obviously effective tools for prevention of non-compliance situations. But what is interesting, the likelihood of usage of such channels by the employees rises by 16% when the internal reporting solutions are formalized, meaning they are expressed in the procedures. And it was obviously the study that was being prepared before the directive forced certain procedures on us, but it all basically leads to the conclusion that we simply need good and precise whistleblowing procedures and documents constituting the system in the organization to use it most beneficially. Well, another study presented in Gallups report that we should also take into account is the one that shows that many employees, this is 15% exactly, do not engage in their work duties as much as they could because they simply don't understand the expectations that the organization states in front of them. And as we all know, the effectiveness of compliance system depends strongly on their level of trust towards the system. We need to build this trust also by using a certain way of preparation of the documents that build the system, especially in the whistleblowing standards. These documents should be understandable, should be clear, and should be user-friendly. And this is exactly here where I would like to introduce you with the idea of legal design. Legal design idea started globally on Stanford Law School, where scientists determined that it consists of at least three aspects: the aspect of accessible graphics, language that is understandable and adapted to the recipient, and the third element, legally compliant content, which brings altogether a whole new communication method. From the lawyer's perspective, we see that similarly, but we also have to make sure that the simplified clauses and the documents are as simple as they can be, but never simpler, so that they remain in line with all the legal obligations and, for example, industry standards or other guidelines that are obligatory for our company. But as lawyers who are also close to business, we also need to take special care to measure the results of every change we introduce, especially the change to the text. For example, from the perspective of emphasis on the most important information on the document and how it helps to remember the most important facts and information within this document. So why remembering is so important? Because another research shows that only 10% of verbal or textual information can still be recalled by an average person after 3 days. While when we use and combine the text and the visuals, more than 65% of that information can be recalled after the same time. So these statistics show that while creating whistleblowing procedures under the legal design methods, we can save our time of communicating the rules because simply the documents are shorter, they are easy to remember by the employees because they take into account also the recipient's perspective, at the same time being understandable and introducing certain innovation to the company. But what I find personally the most important, it simply builds trust thanks to its transparency. Because do you remember how you felt the last time when you were signing a long contract or reading a policy procedure that contained too much of this legalese, right? This legal language that nobody really likes, even lawyers. Well, hermetic and complicated language does not bring any added value to the document and might be actually a barrier against blowing the whistle when somebody doesn't understand the rules. Well, the elements of the legal design methodology are numerous, and the tricks and for the concept are also numerous. Legal design as part of the wider design thinking requires that we take into account the final user's perspective. It can be, for example, here achieved in our situation by inviting potential addressees of here employees reading the procedure at the final stage into the process of creation of documents and consulting the suggested provisions with at least some of them, especially if they represent different streams of workers, different groups, like white collars, blue collars, management, office workers, field workers. They all have different perspective and different understanding. And such approach among the other advantages, it simply increases the transfer of information because the workers are engaged in the process from the very beginning, which might also result in their bigger trust towards the documents constituting the system. The same might happen when we create a simple procedure for investigating the cases, for conducting the internal investigations. The process might be simply faster. And this is exactly what will be required by to use in the whistleblowing procedures because of the growing legal demand. And it is often presented in the new legislation, both on the European and at domestic level. The language of documents guiding the whistleblower through our system, through the whistleblowing rules, they shall be clear, precise, and easily accessible. And the whistleblowing directive repeats that requirement both in the introductory provisions and in chosen articles. But also we can read that in many other legal acts like competition law regulations, which require this simple language that is understood by an average person. Here I wanted to, on the slide, I wanted to provide you with an example of how certain clauses from the whistleblowing procedures might be changed using the legal design methodology. On the left, the first clauses you see, the first clause discusses the freedom from retaliation discussed here today on the meeting after somebody reports internally, and it shows what activities will not be undertaken against the whistleblower, what the protection of the whistleblower includes. The second clause discusses the path that the whistleblower should follow when reporting on different types of violations. But you can see that using icons and graphics and charts and very simple schemes, it is one of the techniques of legal design, and that technique visibly changes somehow unfriendly wall of text into something rather eye-catching and easy to remember. This is only the visual aspect of it, but as mentioned before, it also affects the remembering and understanding and engagement a lot. I also mentioned a lot about the effectiveness of this, what is introduced, and about this economic aspect and of preventive compliance solutions. So following that way of thinking, I think it is worth emphasizing that the effectiveness of legal design can be actually measured thanks to the innovative tools, new technology tools that we, for example, in our DZP compliance team use when we prepare different documents, no matter what it is, the procedure, the contract, the memorandum, or terms and conditions, or some content to the website even. We use that tool developed by Polish IT specialists and linguists from the University of Wrocław, my hometown. And this tool allows us to compare the level of the text complication, its fogginess, and provides a very complex analysis of the text before and after we introduce the changes according to the legal design methodology. And I wanted to show you also the Gunning Fog Index, which is an international tool, because I think that in the changing world, the work of lawyers and compliance specialists, when they create documents that are directed especially to at a big number of employees, like in Skoda or Violi or many different other companies I mentioned today, it is extremely important to take into account different level of, for example, educational background of our employees, different streams they work in, and potentially different understanding of documents that are directed to the very wide group of people. And to make sure that these whistleblowing rules are understood, are respected by as many of them as possible, it is worth trying, because it simply influences the potential risks that the organization can bear, the potential liability of the organization, and obviously at the top of that, the financial and reputational stability of the organization. To sum up, you can share this, you can take this key takeaways with you, but here I would like to engage Wojtek and ask him whether these methods that I shortly discussed, because this is a topic I could talk long about, are used from the practical perspective, and they are not only the academic topic. So Wojtek, if you could please tell us how the different types of employees in your organization, because I know you have different streams of workers, obviously office workers, management, but also field and blue collars worker, how they respond to the implementation of whistleblowing procedures, and whether did it require from you and your company different approach, different way of rules communication to those different streams.
Thank you, Julia, for that question. Before I start, thank you for the introductory presentation. It was very interesting, and also the way you present it's a clear maybe inspiration for how we should present information in a more simplified way. So I also like the way how you did present it. A few comments just before I go to the question. I absolutely agree. Whistleblowing is a very important topic, but in the field of compliance or in withholding companies' reputation, this is only one of the elements. So we should not forget, whistleblowing is only the one element of a working compliance program. So we take it as such, but it should be definitely operational. And I fully agree with your statement about the significance of not only legal design, but in general, a structure in how to provide information to employees, because, and you are all legal experts, so we are speaking now about one type of regulation, but generally there is a lot of regulation coming to all of us in the public sector. But if we translate it into the private sector, it can be even more. So this is one of the biggest challenges the corporates have as well, how to translate this message in a structured and easier way, how an employee or even a manager should know what is important for me at the point when I make my decision, and how can I get this information in a structured way, explain in such a way that I understand that. And now to your question about different type of workers. So we have all the types you can imagine, up to low-level blue-collar workers. So this is a particular challenge, but what helps is, of course, whistleblowing is amongst those systems which we introduce. It's not the only one. We have similar type of systems which help us to practice with these different groups. I would mention health and safety, because we are infrastructure type of company, or utilities type of company. So for us, health and safety is also, environmental issues are quite important ones. So definitely you cannot communicate it the same way to the different structures. They are responsive to different type of communication. When I go to the blue collar workers, they are naturally bound to their superior team leader, to which they trust. They spend a lot of time together, sometimes even in difficult situations when we speak about health and safety. So you cannot use a corporate canon to inform these people. So the second thing which you need to take into account is definitely the type of channels that can be used. So obviously those blue collar workers typically don't have access, or at least at daily level, to emails. We have different age groups, so they are not responsive to all the types of modern communication. So we are a very good example of a company which needs to combine different type of channels. So with blue collars and older generation, the traditional type of methods work in our companies. It's for them, it's very natural to be in contact with superiors, even with managers. So in some companies, smaller town hall meetings are quite efficient, where you have different type of topic. And if you want to strengthen the importance of topics like whistleblowing, that we we very clear tone at the top message, simply saying it's important, your voice is heard, we trust your voice. Nevertheless, what I would like to say, in a corporate world, whistleblowing is only one element how to hear the voices of employees. So we call it not the last resort, but one of the resorts employees can use. So we are happy if they use also other channels, through the managers, through the compliance network, other network, or we created networks of ambassadors which help to translate the message, but also send the message back from employees to other structures.
Well, yeah, exactly. You just mentioned one very important factor, that although we might think of the procedures as spiritless documents, in fact, they need to be very often not only supported by something easy and user-friendly as like graphics or icons or colors, but at the end of the day, sometimes it might be crucial that we engage this human factor and base our communication on actually this human relation, like you said, leader and team member, which might be extremely important for the communication that really hits that person that should understand the question. And also you mentioned the inclusiveness of those channels, as you said, the different groups age, or maybe we could also consider this digital
capabilities. Absolutely.
Yeah, this must be also taken into account. And do you think that engaging all that methods of communication in different forms, it affects the work ethics and the environment in the earlier companies, that we try these different forms? Do you see any real life result in that, or is it just something that you try and observe that, and you see that it should be done, but then we need to wait a little bit for the fruits of that approach?
Yeah, definitely yes. I have quite a positive example. It's not directly linked to whistleblowing, but whistleblowing was part of the implementation. We have recently, as one of the first companies, or the first company in Czech Republic, implemented the ISO 37001, which is the anti-bribery standard. As a French company, we had to embed also the law Sapin-2 or Sapin-2 law elements, which also includes whistleblowing as one of the 8 pillars. So, and if I may document it at one thing, so whistleblowing was only one element, but due to the very strong support of management, but not only top level management, but also mid levels, because we sometimes forget about the support from the middle. I have to say that I would say not only the whistleblowing tools, but in general the feedback from employees, if something happens, if there are incidents to be reported, it brought courage to people that their voice really can be heard. So, a very strong commitment of the company to support, in our case it was the anti-bribery, but it can be a different type of project, but it's dedicated to just ethical culture, or just obeying to certain regulatory rules. It definitely can work and encourage people to report, not only through the whistleblowing channels, but generally to come with potential incidents or things that may not look like so good, and coming also through various channels. So definitely yes, and for us it's very positive also that our work made sense, Now, of course, it's the delicate matter to how to handle the things and how to encourage people further, because there is always a risk with those reportings in general that it gives a word in the company, and then some people maybe may react negatively to that, because we are simply people and the culture is formed by those relations. So we have to be very sensitive to continue this communication towards people and support those who have the courage to report, for instance, incidents that happen.
Yeah, that's great. You mentioned this anti-bribery standards of ESO norm, and that I'm happy that you received a good feedback. And it proves only that these solutions are not facade, you know, that it's not artificial, but it's truly understood by the employees, and that the communication of the rules was effective. And are there any special plans that you have when it comes to the communication and of the new legal changes towards the employees? Because you already had something, and already you built your whistleblowing standards, as you mentioned, because of the SAP and do regulations. But do you find it a challenge for the group due to the fact that the whistleblowing will be now set all across Europe? Is it a challenge when it comes to the communication of such a change of legal character?
Yeah, definitely. Myself, I'm responsible.
Well, sorry to interrupt you, but we are really out of time. So can you make the summary of your presentation?
Yeah, sure. We will just go to the summary. Just one thing Wojtek will add and will summarizing.
Absolutely. Okay. Definitely what I would like to say, I'm responsible for 12 countries, so the complexity is there, different type of approach of local regulators to the adoption, different internal regulatory measures. So this is the complexity. When it comes to the implementation, I would maybe share with the colleagues here that what is important really, and I truly believe in a kind of combination of legal language or plain legal language with behavioral type of communication, which can be shown either in trainings or also in infographics. We also used comics like behavioral situation, what an employee should do. So if you enable the employee to observe a similar situation he might occur, it might be more likely that he or she will report. So really to create this confidence that it's a normal situation in life. So I truly believe in a behavioral type of approach combined with the proper language.
Yeah, I think this is a nice thing to use as a closing statement, that no legal change can actually exist and function in practice without this support of the communication that is user-friendly and that is simply human, often engaging this human factor when somebody really needs to engage and talk to the employees about the rules we're implementing to make sure it's all effective and not only a rule hidden in on the shelf. Thank you very much, Wojtek, for sharing your perspective and joining our conference. And thank you all to all the organizers for letting us participate in the discussion.
Thanks a lot, Lilian. Thanks a lot for the invitation as well.
Okay, thank you very much for your presentation. And there is one question from Professor Hein, and the question is for Mr. Stoniek. You mentioned that at Škoda Auto you accept anonymous reports. Are there a lot of them in relation to the total number of reports? So the question to Patrik Stoniek. May I ask to answer?
Yes, of course. There are only few, I would say 1 or 2 per month. Not so many.
Okay, so thank you very much for all panelists for the presentations, and now I would like to thank also to Dagmar Skupie, because she prepared this wonderful conference. So I think if I thank her, so I think this thanks is also from all of us, and I think she also prepared the comparison of the whistleblowing protection in Visegrad countries. She prepared a summary of proposal for changes. So may I ask, Dagmar, the floor is yours.
Thank you, Professor Varga. I'm in a privileged position, actually, because I had a pleasure and honor to listen to all those enriching presentations. And now I would try to present at least certain proposals for changes that we have elaborated together within our WhistlePro team. And if you have received the book of abstracts for this conference, you have seen the list of our experts who contributed to our not yet completed results, but maybe the results in the working version, which will be further improved, elaborated, so that we could go on with the planned publications. I will be speaking about it in the very ending of my presentation. So we embarked on this WhistlePro grant financed by the International Visegrad Fund last year, with the aim to contribute to developing a model, a set of proposals for the effective protection of whistleblowers in all the Visegrad countries. France and Slovenia were inspiration for us as countries with advanced legislation in the field of whistleblowing, and Slovenia also the Central European country sharing the same past. Very soon afterwards, we realized that the starting point for our countries is different, as France, Slovenia, Slovakia, and Hungary have special legal acts concerning whistleblowing, even though these pieces of legislation are not comprehensive and they are not fully compliant with the EU Whistleblower Protection Directive that we are focusing on. Still, the situation is different than this one, which is in Poland and in Czech Republic, where actually, despite different bills, different proposals, also coming from non-governmental organizations, from trade unions, as for example in Poland, the legal proposal for Whistleblowing Act prepared by Batory Foundation and trade union organization Forum Związków Zawodowych and Helsinki Foundation and Institute of Spraw Publicznych, even though there were certain attempts also from the governmental side in our countries. So far, this protection both in Czech Republic and in Poland is dispersed, is granted by different legal acts. Besides special legal acts, or notwithstanding their absence, there are sectoral provisions which are certainly inspired by the EU law, which transpose EU law, and also protection granted on the basis of labor law. So far as it was indicated during the conference, though preparation of transposition acts started, and we are awaiting transposition acts in all the countries covered by the grant, There is no implementation of a EU whistleblower protection directive so far, and still national legislations need changes, need improvements. So main shortcomings of the present situation certainly are such that in the absence of a comprehensive legal act sacrifice for the protection of whistleblowers, there are different levels of protection, with protection against retaliation usually exposed, except for Slovakia and Slovenia, where there are some possible interim reliefs for whistleblowers before the employment contract is terminated. There are no clear rules concerning the reversal burden of proof in cases relating to a detriment suffered by the reporting person, except for France and Slovakia, but in majority of countries, there's somehow unclear as it concerns the reversal of burden of proof. Obligatory internal channels only in certain sectors, in majority of countries. And then, except for France and Hungary, where the ombudsman's offices are tasked with orienting a whistleblower to other prescribed bodies, and also Slovakia now developing, enforcing the whistleblower protection center in other countries, there are no such national whistleblower protection centers. It appears from the latest survey, which was carried out in June this year by the European Union, that there's still a lack of information among the European citizens about channels of reporting. So it results that our Visegrad countries are no exception to the EU average, that only a minority of respondents would know where to report corruption. And despite the change of culture and examples of this courageous reporting, also during the COVID-19 pandemic, there is what results from the surveys that we are able to discover. There is still a fear of retaliation, and moreover, fear of being treated as a traitor, which remains a barrier to whistleblowing. So in my presentation, I will tackle only certain aspects of proposed changes. Some of them have already been tackled in presentations of Professor Zbigniew Hein, with whom we are cooperating on the elaboration of the general report, finalizing this grant. Also other persons, our national reporters, national experts, expressed their views on the proposals for changes. So I would like to speak about material scope of whistleblowing, the proper structure of internal channels and external channels of reporting, conditions for public disclosures, measures of support, briefly about protection against retaliation, confidentiality issues, sanctions, and relation between general rules and sectoral provisions. So as Professor Attila Kuhn has already indicated today, taking over only the material scope of the EU Whistleblower Protection Directive would be a bureaucratic move, copy-paste move, let's say, because this directive opens the possibility to cover the larger area of breaches. And I think it's very advisable, especially it is recommended not to wait for any reporting or any EU Commission assessment to include labor law breaches into the scope of reporting and disclosures, and also not only focusing on breaches and abuses of EU law, but also on breaches of national law, such as, for example, as I indicated, labor law breaches or human rights. Moreover, I think that organizations are also free for the optional extension of the material scope of whistleblowing in their internal acts. And I think that where deontological codes are embedded in legislation, are binding, as for example, in the civil service or in other professions, the breaches of deontological codes should be also included in the material scope of disclosures. Disclosures concerning past, present, and future breaches carried out with reasonable grounds to believe that disclosed facts took place. And I think that the approach of the directive, as already Professor Zbigniew Hein indicated, is such that the public interest is not really a prerequisite for the protection, but there must be here a disclosure that does not concern individual dispute of a given person with an employer, that does not really relate to purely interpersonal grievances. And certainly the protection should cover persons who have personal knowledge about the facts, who at least have reasonable grounds to believe that that what they relate, what they disclose took place is true. Internal channels, I agree with Dr. Stransky that the role of, and also Professor Kuhn was speaking about this, that the directive really does not guarantee a proper role for trade unions, for worker representatives, and it could be and it should be amended in the national legislation. Therefore, we suggest that internal channels structures should be consulted or negotiated through collective labor agreements according to national law and practice with trade unions or with works councils according to the industrial relations tradition. There must be a clear information policy about the material and personal scope and procedure of whistleblowing within the internal channel. And certainly there should be a clear information, maybe with the help of a legal design as a method that is really innovative, to inform a worker that there is no duty to report to the internal channel first. As this is an option, this is a possibility, and it is a privilege to have trust in the organization, but certainly the directive does not require the priority of the internal channel. How to organize internal channels? Certainly organizations have more experience than us researchers, but I think it's crucial that these channels use new technologies which enable strict protection of the confidentiality of whistleblower data. There was also a discussion among us, what about anonymous report with different advantages and disadvantages of anonymity. But I think that the fear of retaliations is really so strong that it has a chilling effect. So anonymity would help, and the anonymous reports should be followed up within the internal channel. Internal channel should not be open only to workers, but also to other persons cooperating in the work-related context, which was defined by Professor Zbigniew Hein later on. And of course, I rely here on our expert, Dr. Edyta Biela-Grzoma, who indicated also good solutions concerning personal data protection, and we will have a chance to read about it in our publications. Internal channels should be, in our opinion, organized with in enterprises with more than 50 workers, so that burdens for small enterprises are avoided, of course, with exceptions which result from the directive in all public entities. There are two possible options for dealing with reports. One, this is a creation of a stable department dealing with reports with a restricted number of persons having access to the report. Of course, there must be a special training for persons who analyze the reports, who are responsible for the follow-up. On the other hand, there's a possibility to external provision of a channel. And if the second option would be used, we would recommend here the cooperation with offices of professional lawyers, auditors, or other professional advisors who are bound by the professional privilege and guarantee no leaking the respect of confidentiality of their let's say clients, yes, persons who use the channel, as they have a deontological codes which have to be respected. One may think about a multilingual channel at the level of a group of companies for especially disclosures of cross-border offenses or for reporting on improper conduct of local managements of controlled undertakings. So diligent and quick follow-up is crucial within international channels. And I think that there should be a preference to transfer very quickly after the first examination of the case of circumstances to transfer the case to the external channel, to the prescribed body, if there are suspicions of criminal acts committed. I think that the internal channel is not appropriate for dealing with such criminal acts. However, if the operator of the internal channel, if the organization decides to refer the report, and this is also Transparency International, the organization which also have suggestions for implementation, it is very strongly underlined that there should be a consent of the reporting person to an information given to the reporting person about the transfer of the report to another body or to the external channel. As it concerns external channels, there's a twofold situation in our countries. Namely, Slovakia happily has a whistleblower protection office now. And on the other hand, there are countries with no such whistleblower protection office. So we suggest that the task of orienting the disclosures, the reporting to the appropriate prescribed bodies would be an independent constitutional institution, as it is in Hungary or France with the Défenseur des Droits, with the Hungarian ombudsman. But this possibility to be oriented, of course, it's only an option, so it should not be an exclusive channel, just an office. which has its specialized whistleblowing department. This is also a proposal in France to better organize the tasks within the Ombudsman's office, so that a person who is somehow lost could be better informed about the competent prescribed bodies, where to whom to report. External channels should be also autonomous, effectively protecting confidentiality. I think that anonymous disclosures should also be accepted. Of course, the procedures are different within different prescribed bodies, within criminal procedure or different inspections, but at least in cases of justified risk for health or life of a whistleblower or their close persons, there have to be a follow-up of anonymous disclosures. I also think that there's a little bit of confusion about the competence of European institutions. So national prescribed bodies should also cooperate with institutions on European level as it concerns the possible transfer of a report according to the competence. And this is certainly not the task of national lawmakers, but I think it's very desirable to have a house of whistleblowers at the EU level, due to the material scope of the breaches, yes, of whistleblowing covered by the directive. What I think worries us who have been analyzing Article 15 of EU Whistleblower Protection Directive, this is quite an unclear notion of appropriate action, the negligence of which within the external channels paves the way for the public disclosure, for the safe public disclosure, yes, legal public disclosure. And I think the national legislation should define more precisely what is this appropriate action, the negligence of which allows to disclose publicly. Then alignment of conditions of public disclosure to the case law of the European Court of Human Rights, which was presented today, is also very recommended. What is worrying, this is the wording of Recital 45 of the EU Whistleblower Protection Directive, which states that public disclosures are understood not only as disclosures, for example, through online platforms, social media, but also disclosures to trade unions. So I think that this special role of trade unions should be preserved, and any disclosures to trade unions, to works councils, or breaches of labor law, or other breaches falling under the scope of competencies of these representative organs should not be treated as public disclosure. Various measures of support were already mentioned today. The appropriate awareness-raising campaigns concerning the legal situation of whistleblowers, comprehensive information on the web pages of the prescribed bodies about the procedures of whistleblowing, about the rights of whistleblowers. Then I think that it's very important that a newly created national whistleblower center in each country guarantees free of charge legal advice before lodging a disclosure. And we may also think about granting legal aid during the judicial procedures independently of financial status. What I think it's also a very interesting aspect. This is a right of a whistleblower to require a certification of whistleblower status by the appropriate prescribed body dealing with a given case. Protection against retaliation, I think this is such a huge topic that it will be analyzed in detail in the planned publications within our grant, but certainly the possibility to suspend the contract notice period by a decision either of the Independent Whistleblower Protection Office or by the court upon request of the interested person during the judicial procedure is an important element of protection. Also, justification of the notice in case of fixed-term contracts termination, the right to full compensation or reinstatement in work, and also the extension of anti-discrimination instruments to whistleblowers, like insertion of a criterion of a whistleblowing as one of prohibited grounds for discrimination, extending anti-discrimination provisions to persons employed on the basis of civil law contracts, and of course, last but not least, reversal of burden of proof clearly institutionalized in cases of dismissal of a whistleblower or in case of other retaliatory measures. Professor Zbigniew Hein has already mentioned about the necessity to protect against retaliations, persons preparing themselves for whistleblowing. Secrecy versus whistleblowing. So, first of all, there must be clear rule on the scope of medical or legal secrets, as there are certain cases where barristers or doctors are also whistleblowers and should be protected. Then, even though the directive leaves it to national legislations, I think that also in the realm of national security, there must be ways, structures to report on breaches covered by this sector with an appropriate institution competent to receive reports with a guarantee of full confidentiality. And of course, it is a huge issue, but still there is no cohesion between the protection granted to whistleblowers on the basis of Trade Secrets Directive in comparison with the EU Whistleblower Protection Directive. Yes, so I think that these conditions to immunity, to exoneration from criminal and civil responsibility in case of the alleged trade secret, which in fact is a justified legal whistleblowing, these conditions should be improved. Also with reversal of burden of proof in civil cases concerning the alleged breach of a trade secret by a whistleblower, what is lacking right now. Sanctions, I think that, of course, sanctions may be imposed both on natural persons or legal persons. In every case, it should be effective, proportionate, and dissuasive. So one may think about the imprisonment penalty in the most serious cases of breach of confidentiality of whistleblowers' personal data by natural persons, and financial painful penalties for organizations which are obstructing or impeding reporting. On the other hand, I would like to draw your attention to the Council of Europe resolution of 2007, which recommends to the parties the abolition of penalty of imprisonment in cases of defamation which do not concern hate speech or negationism. The resolution is called Towards the Criminalization of Defamation. Sectoral provisions, of course, establish certain standards, but sometimes these standards are higher then they should be preserved for certain sectors. But on the other hand, it is necessary to apply minimum standards, which will be soon, I hope, established by general rules on whistleblower protection, also to reporting in sectors enumerated in the Annex 2 of the European Union Whistleblower Protection Directive. So now I would like to invite you to see the developments on our webpage, because in the autumn we will be publishing the results of our grants in one English language publication towards a better protection of whistleblowers in the Visegrad countries, France and Slovenia, and also in micro publications in Czech, French, Hungarian, Polish, Slovak, and Slovenian languages in a more concise form with our proposals for changes. So thank you so much for being with us despite such a late hour. And now, if there are no comments here on chat, I would like to thank all of you for being with us today during this long but very enriching journey into different countries with different legislations on whistleblower protection. I would like to thank you, speakers who accepted our invitations, who had brilliant speeches, all participants, viewers on the University of Łódź streaming media, interpreters, our technical team, colleagues who were members of the organizational team with me. Thank you so much. I would like to kindly ask you to spare us an additional moment to fill the short survey of your satisfaction. Please kindly be with us for a very short moment to fill this survey. Now I am ending the live transmission. Thank you so much for your attendance.